My lord, may I permit to mention a leave?
Mention?
Mention a leave. My lord,
Yes.
the petitioner's name was
Please loudly, I cannot
the
hear.
petitioner's name was arbitrarily removed from the electoral roll, my lord, and she doesn't get any chance to defend her case, and she was not served any notice or summon. Also,
It's not a land matter.
no, my lord, it's a SIR matter, my lord.
I do not have determination. I do not have determination. Yes, call the list.
The interim order expiring on the end of May, so I am praying for extension.
What are expiring? Yes. Yes.
Lordship, I am appearing for the petitioner, my lord. My lord, in this matter, on the last occasion, your lordship has pleased to direct, my lord, service of copies of the writ petition as well as the report by the state upon the appointment of GP, my lord. But till date, no appointment has.
Posting it after the vacation.
My lord, not after 2 days, my lord. On Friday. On Friday, my lord.
Friday, anything will be done. You are sure?
I have no idea, but still, my lord.
Uh,
My lord, kindly then fixes a date, my lord.
after the vacation. Yes, next.
Extension.
Extension.
Yes, Lord. Only one thing, Lord, they've been enjoying it for 11 months.
How big?
Well, lease has been terminated.
Then no interim order, Mr. Basu.
Lord, lease
Leave has been
terminated.
terminated. There is no question of extension of interim order.
I will answer. Is there any power for termination? আরে কিছু বলতে পারে বলে দিলি এমনি এমনি এক্সটেনশন হবে এমনি ফি হবে মানে ওটা status quo in respect of the
Subject property, my Lord.
subject property.
Let us go. You are in possession.
Yes, yes. Order dated, my lord, July 2015, 2025.
15 বলে। 1st July
কম দেখি
25.
তো just is
You are
sent.
in possession in what capacity, Mr. Basu?
I have been allotted. I have been allotted lessee.
Condition to pay.
There is no dispute about that.
Are you paying?
Yes,
See,
Atmar will not come. Atmar will not come. I am paying.
you are not. You are paying. Or
Yes, yes.
They're breached. There are substantial breaches for which we terminated. They're supposed to carry out certain works, my Lord. It's allotment by
How
the
they are
state.
paying?
Well, it's not about the money, my Lord. It's about, my Lord, construction of schools and universities there. Instead, they went ahead and started constructing hotels.
The formally, the state also has to be.
Not only state, he has put a right question to me, not to the court. This is the state government undertakings.
Whether I'll
Nobody
have a
knows.
brief or not, I don't know.
Yes.
Grateful.
Grateful.
Number 3, item.
Yes.
This is my affidavit of service.
Of the private,
Appearing for
private.
This application is for my lord against the my lord encroachment on PWD land.
where is the representation?
Representation, kindly take page my lord 16 of the petition, and this is the photograph.
দেখিয়ে দাও না হ্যাঁ না দিয়ে দাও তো ফটোগ্রাফ বলেছে ওদের আছে আমার না
It's a case of encroachment which you have made. Encroachment upon your land.
Not my land, my lord.
Please see representation at page 13.
Yes, that was my lord. I am saying, my lord, this representation was made prior, my lord. Prior. And in pursuance to this representation, another repetition was filed.
That has been removed.
That was withdrawn, my lord.
Encroachment upon your land has been removed. Yes.
No, I am not saying, man, regarding.
Your representation at paragraph page 13.
Yes, I am seeing, my lord. That I am saying, my lord, so far the encroachment on my land, I am not on that part. That will be dealt by the civil court. But so
Where
far,
have you stated that in the writ petition?
yes,
Please show me.
kindly see paragraph number 5. And also I have stated in the representation to the assistant engineer.
Paragraph 5.
Paragraph 5.
Yes.
That the petitioner states that land portion bearing GL number such and such under Moujad such and such, Khotian number such and such acre, about 3 decimal land was sold, executed and sealed to the winner.
Constructed.
That's on my private land.
That I,
Private land.
Yes.
yes.
And kindly see
That
the
was my lord.
construction which is complaining. See the construction which is complaining. Before that, they have filed a writ petition before Group 5 also, which
That
was
was my,
later withdrawn by them, my lord.
yes.
That has not been disclosed in the writ
Yes,
petition.
my lord, kindly see the order, my lord.
They have not
Have
said
you
anything
disclosed
about
that?
nothing.
My lord, that on the technical ground, my lord, that was withdrawn, not praised, my lord.
For that you will not disclose. Your representation says encroachment upon your land.
Not my kindly see page number 16.
You will not disclose.
No, that was withdrawn on technical ground.
Disclose that.
That writ
You'll
petition
honor
was
that.
based
Yes,
on
my lord, that I will file
You'll
submit
honor
to
that
affidavit.
advocate appearing for
Grateful, my lord.
yes.
I came earlier before you.
Yes, Mr. Vadajaji, what do you want?
And Your Lordship passed an order directing the ADM to reconsider the same.
State is a sorry party, Mr. Vadajaji.
State government is also a party.
State is not here. What can be done?
But the order which was passed, only one, that order which was passed,
Yes.
in the order it is been stated that it
Where is the order
cor-
which you are challenging?
it is the corporation who is the competent authority. Page 114.
But corporation, I do not know. The panel of the corporation has also been changed.
Yes.
So I'm still there, but the copy has not been received by my client as I
Not been received. So can you appear? So
No,
I'm directing you to serve. Uh,
No, my lord, the order which has been.
Mr. Shah, learned advocate who usually
14 and 11 portion. There are 11 portion at page 117. 117. Kindly see page 117, paragraph 11 of the order.
Application has been rejected.
Yes.
So then without the hearing them, yes, by the order impugned, is served upon the GP after the panel is prepared.
Let
If
it
service
be
taken on-
accepted, my lord.
তাহলে একটা উপরে লিখে দেবো, if his service filed in court today is taken on
Yes.
record in spite of
Yeah,
this,
again, I took kindly note.
yes, ওটা নিয়ে নিন,
Again, kindly.
সার্ভিসটা নিন, সার্ভিসটা নিন, yes.
Item 5 is honorable categories
State, where is the state? Without the state,
I have served. Affidavit of service on the direct GP and also on all the respondents.
there is no panel now.
That is all right, but I think.
What is the urgency?
But there is urgency because I am challenging an eviction notice issued by the forest range officer beyond jurisdiction. But 33A was invoked, but in the facts of the case, there is I can place that, but let Mr. Chatterjee come. Yes.
Pass over next.
Item 6, Lordship kindly keeps it after the vacation.
After vacation, next.
I prefer the respondent number. I appear for the petition number.
Respondent number 10 on.
Private respondent.
Private respondent.
But there is a notice issued by the State Highway Authority pursuant to your lordship's order.
Removal of encroachment.
Yes.
Removal of encroachment.
But he is claiming to be the owner, the private respondent. But I am also the relatives, my lord. And I say, my lord, the land in question, my lord, has been wrongly recorded in his name. And an application has been made for correction of that particular land. Now, my lord, the question is, my lord, kindly come to your lordship's previous order once. This is the second round of litigation. That is at page
Yes.
46.
46.
46. But I pray for an interim protection.
What interim protection?
But just my Milord, just let me place my case. Subject to correction, Milord. Page 46 is the relevant portion. Petitioners
Protection, what do you want?
a stay of the notice.
Which notice?
Notice at page 50.
50.
50. Milord, what I want to say, Milord, in the notice encroachment of they are saying government road side land. Milord, what is side land, Milord? I don't know. And your lordship's order was if it was encroachment on government road.
So it's only section 10.1
10.1.
notice has been 10.1 notice has been issued.
Yes.
10-1 notice has
So if
been.
you do not remove the encroachment, it will be forwarded to the
Magistrate.
subdivisional magistrate under 10.2.
Milord, the
Then the
question,
subdivisional magistrate will pass an order under 10.3
yes,
upon considering your case.
yes.
So you can raise all points there.
Well, the question is one thing, Milord. Kindly visualize one thing, Milord.
Great.
Don't,
Not at this stage. It's premature now.
Milord, kindly allow the
Premature
survey
now.
and everything, Milord, may be given to me. Survey and everything, Milord, may be given to me.
Take all points at the 10-3 stage.
Then my lord, kindly keep it open. My lord, kindly give liberty. I can
That
say,
liberty is necessary. You are entitled to as per the law.
but still, my lord, kindly one line because my lord, I will lose everything. My
You
lord,
are entitled to as per the law.
one line.
Ashun.
Hmm.
The petitioner. Yes.
Eight and 9, we are seeking for a short passover. Documents of settlement are being affirmed, Your Lordship.
Documents of settlement are being affirmed.
Affirmed, Your
So it's settled.
Your Lordship.
Where are
Kindly
both
keep-
the parties?
My lord, only, yeah, it is, I beg to appear on behalf, my lord, of the petitioner in one of the matters. Your lordship recalls that is that Bancharam matter, my lord, which Mr. Shuddha Satya Banerjee was on the other side also.
Yes, now it has been settled.
Now they are affirming an undertaking, my lord, which they will file in court in order to make the settlement effective. Please keep it, my lord, at 12 p.m., my lord, on my request. It will take 2 minutes.
All right. Both of you have gone through the draft of the
Lordship, everything has been.
terms of settlement.
Yes, my lord, I have gone through it. They appear to be legal. There is no difficulty that way. And additionally, in order to enforce it, an additional undertaking is being furnished in court, which can thereafter be proceeded with in appropriate.
Right. Orders, madam. Yes, next.
My lord, item number 10, landed advocate Dheeraj Trivedi is appear the Eastern Railway, my lord. Kindly short passover, my lord.
About short passover.
Where is he?
My lord, he is in front of on 12.
Front of?
Sorry. Apologies, my lord. He is
Where?
appearing before court number 12.
Hey.
Mr. Trivedi.
He is very busy because in many matters.
Place after vacation, the order was passed on largely.
I'm passing it over. Short passover 12.
I'm not sure. Let it remain at 12 if I'm able.
Ask Mr. Trivedi to come at 12.
আজকেই করবেন নাকি এসে আবার করবেন? না আসছে তো বটে।
Number 11, 12, 30, 40, 50,
20.
That's the document too.
90.
Yes. Union of India. Yes, what is this matter?
Lordship, the petitioners are not satisfied with the compensation.
Not satisfied with the compensation.
Yes.
National Highways Act.
National Highways Act. Already you have passed, Lordship,
You have to approach the arbitrator.
You have passed to order, Lordship. So, you have passed to order.
No, if you are not
Previously-
satisfied with the compensation amount determined by the competent authority, remedy lies before the arbitrator. 3G5. Yes. I've passed that order only.
Yes, Lordship. This
You apply under 3G5, that will be considered.
Lordship, representation also done. Representation also done.
Representation will not do, madam. The order which you have produced, there also a representation was made. So you are relying on this order. It says representation is not sufficient. You have to approach the arbitrator in accordance with law. Representation will not suffice. Where is your representation?
Page number 195, Lordship.
195. $195.
Pardon me, 193. 193. Pardon me.
193.
193.
The competent authority. Now it's to be referred to. You have received the amount.
Yes.
You have received the
No,
amount.
no, 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 no,
You have not
Lordship,
received the amount.
notice. Just notice we have received.
If Yes, next.
Lordship, will it be my lord's pleasure, my lord?
Yes, yes. Yes, Mr. Trivedi.
Apologize, my lord. Will it be my lord 12 o'clock? The matter is fixed.
You want it now? Mr. Bhattacharya, you are ready? Yes.
Next matter only, they were supposed to bring instructions.
10, I am appearing for the union.
Item number?
10.
Oh, 10.
Yes. Instructions. They are having the instructions.
So I don't know, my lord.
Lordship,
Next matter.
we do not have the instructions yet.
So
Your Lordship.
what do you want?
We need some time, Your Lordship, to seek instructions.
10 or 20?
10. Passover matter 10.
Mine is 20.
Yes.
Item number 10 was called, I believe.
Yes. 10 has been called.
Yes.
So,
Which 10 you are
Trivedi is appearing.
They have instructed me yesterday. No, you tell me. Otherwise, I'll retire.
The instructions you have got.
Lordship, instruction, it's the case itself.
Mr. Trivedi, what is troubling is you have
Public
must have-
Premises Act and 147.
Yes. So you have referred to this.
I have
If you
referred.
to these provisions. Then the question is whether you have followed those provisions of this statute.
Some morons. Lordship, what I submit, Miller, there are judgments of this honorable court, Miller, which I have now, Miller. 147 has not been declared as ultra-virus. It is intra-virus. Now, Lordship,
to larger bench.
I know that. My Lord Justice Shobhashachi Bhattacharya.
I'm not saying. I'm saying that you have invoked that. It's not ultra-virus.
I have not.
You have invoked that. Please show me what proceedings you have initiated.
My Lord, we have not invoked that.
But your notice says that.
My Lord, that notice, my Lord, may I say, as far as this land which we are invoking 147 for, it is infested by unauthorized illegal occupants who just come and encroach on railway land. And therefore, 147 has been promulgated. This honorable court in 2013, then after that, latest judgment is of 2024 of the honorable coordinate bench of this honorable court, which says that we can take steps in accordance with law in spite of this particular issue pending. Now, Milord, what happens when public premises comes into being? Supposingly, in the railway platform or any of the properties, we have our schemes by virtue of which we grant licenses to people. And then subsequently, on revocation of license, they become unauthorized occupant. And then what is to be followed is the Public Premises Act, because they are unauthorized occupant or occupant under the provisions of Section 2F CNF. Now, some people who come and invariably encroach, my lord will find there are many railway tracks where on both the sides bastis are there, and in Kharagpur and everywhere. Now, my lord, what happens is we have this right whenever we have a project to undertake, my lord. Under 147, we invoke and we are well within our rights to suo moto evict them, and that does not mean that there is any, my lord, they have any right, because 147(2) gives us the right to execute by way of police help. Or now, lordship, what was sent for adjudication before the larger bench by my lord Justice Shobhashachi Bhattacharya, that was judgment of 2022, if I'm not mistaken. There, my lord, the factual matrix was slightly different from what it is. Now, my lord, what happens is here, this particular notice which we have given, it is not a notice in personam. It is a notice in rem. Now, what happens is, with these places, now we have got a particular project in place, which I will place before my lord, and we have got those documents.
The only thing that is troubling is that you have mentioned in this notice, yes, maybe in rem, maybe a public notice, not intended to a particular person, but the public in general. But it specifies that
my lord,
two provisions of the statute,
maybe,
or two statutory provisions have been invoked.
If
you have invoked that, you have to show. It's not their case that you have invoked. It's your case you have invoked. You have invoked the statutes. You have to show that
it is not my case. If my lord kindly comes to the notice, first of all, that notice is neither signed nor it has any number. So, my lord,
how
So
we are inquiring into it.
You are not taking steps pursuant to this notice.
My
I
lord,
can record
no,
your
my lord will kindly give me 30 seconds to explain my position. Since my lord has deliberated on the matter and passed an interim order, and a notice has been given, and it has been stuck. Now, my lord, I have whatever internal issues we may have, whether this word Public Premises Act ought to have been mentioned in the notice or not, that is an internal inquiry which we are taking, we will do that. Now, I have to, my lord, I have come before my lord to say that even if this notice is given, this is not bad in law, and it does not mean that if I have given this notice, I cannot invoke 147, but I have to invoke Public Premises Act. Because, my lord, factual matrix of the case will prove, my lord, the petitioner before my lord has come up only with one document, that is this notice. What locus he has to occupy that land, whether he comes within the definition of occupiers or unauthorized occupant under the Public Premises Act or not, that will give him the right to have an adjudication done with regard to his possession under the Public Premises Act. A person who is, now we give a notice, for example, maybe we have some people over there who have been given license, maybe those wheelers or and large number of people are there who are basically unauthorized occupants. Now, this 147 and one.
According to you, there may be some of the occupants to whom this Public Premises 71 Act or the Railways Act 1989
as far as here is
will apply,
what I
may
want.
not be to the petitioner.
My lord, here what I am humbly submitting it, my lord. In fact, the place where all these people are there, it's a big basti where all are illegal occupants who have encroached on the government. Now, my lord, what happened is now we have floated a particular, we wanted to make a bridge and form up, we are having, my lord, a project where, my lord, we are wanting to basically, lordship, we have a proposed building which we are proposing to come up over here. We want to have a booking office, and we are also wanting to extend our platforms for it. And this whole portion is, lordship, encroached. So, my lord, we wanted to remove them. We have given 161 notice to them. No, I 147. I stand corrected.
147 of the Railways Act.
Now, my lord, this applies to all these people. Now, my lord, my lord will have to take this particular case as, because my lord, only one person who is the petitioner has come before your lordship. He has come up and says that a notice has been stuck there, and I am basically going to be evicted within 48 hours. Therefore, your lordship was pleased to grant an interim order. Now, my lord, the first question I'm asking myself, my lord, first to the interim order which he will enjoy. My lord, what right he has to enjoy that interim order if he can produce a single document that brings him within the Public Premises Act. I apologize, my lord.
Of the public.
Lordship, I apologize. You have a public premises? I apologize, my lord.
What?
I apologize for not having the book, my lord.
No, we have been provided with a book.
No, my lord, I was carrying it, my lord, because of my running helter-skelter there and there, my lord.
Maybe the Railways Act I may need.
My lord, I have Railways Act, but my lord, before that, my lord, lordship will kindly come to section 2.
Yes.
If lordship allows me to place.
Come straight away to G.
G, my lord. Yes, my lord. Now, my lord, C is also temporary occupation is also important, lordship.
C is
temporary occupation in relation to any public premises means occupation of any person on the basis of order of allotment made by under the authority of central government. Then lordship, unauthorized occupation in relation to any public premises means the occupation of any person of a public premises without authority of such occupation, and includes continuation of occupation by any person in public premises after authority, whether by way of grant or other mode of transfer under which he was allowed to occupy the premises has expired or has been determined for any reason whatsoever. So, lordship, there should be some semblance Then Lordship, FA, that is at 2FA, that is
Yes,
residential
according to you, the provisions of this act shall apply only if the entry was pursuant to some grant.
Yes.
Thereafter,
Yes.
there was termination of that or continuation after expiry of the
Yes,
grant.
because
So then
public premises.
merely a person who encroaches upon a public premises for eviction of those persons, this act may not apply. That's the
Yes,
sum and
Millard,
substance of
because
your-
Millard, yes, Millard, that is the sum. Why, Millard? I tell Millard, because under 147, if Lordship kindly takes up
of the Railways Act.
Lordship.
You have a copy of. You have another book.
Millard, I will get it. I have.
Railways Act আছে একটা থাকার কথা দেখি। You can take that. Yes.
Just tell him I'm on my legs, I'm coming up. Apologize, Millard. I've been now summoned by another honorable division bench. So, Millard, I apologize, Millard. This will be over within 2-3 days, Millard.
2-3 days.
Millard, otherwise I will be over. My books are going as helter skelter. Matters are not being. Millard will kindly take up 147.
Yes.
Trespass and refusal to desist from trespass. If any person enters upon or into any part of railway without lawful authority or having lawfully entered upon or in such part misuses such property or refuses to leave, he shall be punishable with imprisonment for a term which may extend to 6 months or with a fine which may extend to 1,000 rupees or both, provided that in absence of any special or adequate reasons to contrary to be mentioned in the judgment of the court, such punishment shall not. Now, Lordship will kindly come to 2. Any person referred to on
subsection 2 of
Lordship
147.
may be removed from the railway by way of railway servant or by any other person whom such railway servant may call for aid. Now, Lordship, so Millard, these 2 sections are not mutually, they are mutually exclusive. What I'm trying to. Now, Lordship will kindly allow me to place the petitioner's case before my Lord. What he has said before your Lordship. He comes up straight away.
This section was challenged.
Virus will know.
What is pending before the larger bench?
My Lord, what is pending? That particular judgment also. My Lord will kindly take up this judgment. It's an unreported judgment. And
copy to Mr. Bhattacharya.
Yes, my Lord, I'm giving. First, my Lord, a reported judgment of 2013, SCC Online, Calcutta 15752. দিচ্ছি আমি দিয়ে দিচ্ছি স্যারকে দিয়ে দিচ্ছি স্যার my lord, here if your lordships, this was before my lord Justice Sanjeev Banerjee, my lord, and here my lord this question was cited, my lord, and if my lord kindly comes to, if my lord kindly allows me to place my lord, categorically, my lord, in paragraph.
There's no paragraph. Yes.
No, Lordship, I'm coming. If my lord kindly takes up page 7, that is the penultimate page. If my lord, may I be allowed, my lord? The 3rd paragraph from top. There is no absolute rule that the state may not evict a person from government premises without obtaining a degree therefore. The general law that requires the lessor or an owner of the property to evict even a trespasser therefore only in accordance with law requires a degree to be obtained for the purpose of eviction. But if a special law is applicable, such provision may be resorted to. Such special law may be the Act of 1971 in respect of public premises covered thereby or state laws in respect of the premises specified thereto. Like the 1976 Act of the state, as long as there is a valid law that permits eviction of a person from a property, the general law would no longer apply to the case. The validity of section 147 is not questioned by the petitioner. Its efficacy and applicability in the present case is only doubted. There does not appear to be any charter to read Section 147 of the Railways Act to imply that the railway servants would merely request a licensee in occupation of the railway property after the expiry of the tenure with folded hands to remove himself from the railway property and be powerless if such persons politely decline the invitation. Section 147 of the Act permits eviction by force, and merely because the magic word force is not used therein cannot be a ground to emasculate the provision. The petitioner's case typifies the manner in which railway properties have been occupied, sometimes with unhealthy dollops of judicial overgenerosity. There may still be several unreasoned orders of this court subsisting in favor of similar placed licensees that have been throttled the railways from generating revenue and financing the services that is mandated to deliver. Just as the provision of Civil Procedure Code pertaining to execution of an eviction decree do not expressly refer to the word force, Section 147(2) of the Railways Act also does not do so. But just as it is open to an executing court to direct the bailiff to dispossess the judgment debtor with police assistance, the second limb of Section 147(2) of the Railways Act permits the use of reasonable force for any railway property to be relieved of the unwanted occupants, including the licensee clinging on possession after expiry of the tenure. Now, here, Millard, his entry was proper, but then also this honorable court said that 147.
According to you, your case is on a better footing.
My case is on a better footing. Then Millards will kindly come to this judgment, which has taken into consideration. It's an unreported because I could not find the reporting of this judgment in any of the journals. Well, this is of 2024, Millard. Here, Millard, there was a cooperative society which had certain rights because at one point of time, they were put in possession with some licenses, some were not, Millard. Now, Millard, it was decided that they can be evicted under 147. If Light Lordships kindly allows me to please. Now, Millard, may I please? The petitioner is a cooperative society. It is alleged that its members have been running business from railway land since long. The writ petition has been filed challenging the notice issued by the competent authority requiring the unauthorized occupant on railway land and or around Chandanagar railway station to vacate the land, such land, failing which the authority reserved the right to drive. It is contended by the petitioner that the notice was issued without hearing the petitioner and without following the order of the coordinate judge. If it further contended that Section 147 of the Railways Act could not be imported in the instant case, the question as to whether the said section would prevail over the Public Premises Act 1971 or not is pending before the Honorable Division Bench of another matter. Now, my lord, this was the contention which was before this bench. Now, Lordship will kindly allow. The learned advocate further submits that the hearing was not granted. Thus, the order suffers from vice and violation of principles of natural justice. Relying on page 115 of the writ petition, it contended that some time was prayed for by the petitioner at hearing, but the same was not granted. For reliance, he has placed, well, this is now, Lordship, the submissions are there. Where in this judgment, Lordships, the other judgments have been taken into consideration. If my lord kindly comes to paragraph 9, yes, where other writ petition which was disposed of by the Honorable Coordinate Bench has been taken into consideration. Then Lordships will kindly see this particular judgment has taken into consideration, and my lord will kindly see come to page 7, paragraph 17. It is not incumbent upon the authority to give as many hearings as the petitioners desires. Further, none of the encroachers have come forward who are allegedly members of the society and affected by the order impugned. The fact that there are encroachers is not disputed. A coordinate bench in the matter of Subroto Ghosh, Union of India and so has held that a person in unauthorized occupation of a railway land shall be treated as trespasser, and Section 147 of the Railway Act 1989 gets attracted. However, his lordship was of the view that while enforcing Section 147 of the said Act, the principle of natural justice should be observed. His Lordship relied upon the decision of Durjoti, which I have placed before my Lords. Now, Lordship will kindly come to the page 11, paragraph 19. Under such circumstances, this court does not find any reason to interfere with the decision of the authorities. Moreover, the railway authorities have already allowed such persons who have been in unlawful occupation to approach them after completion of project under the scheme for license and lease. In shopping complexes, this indicates that the authority has considered the question of livelihood and decided to permit persons to run their businesses in certain terms and conditions. Now, Lordship, if my lord, I am trying to take my lords to, now my lord will kindly come to paragraph 20.
Yes.
It has also held clearly, it has also been clearly held by the court that all that was required for the railway authorities to do was to ensure that the affected parties are heard. In this case, the members of the society were before the authorities. Whether the argument made by the members were to their satisfaction or not is not the concern of the railways. The individual members of the society may approach the railway authorities with their prayer for grant of lease and license in respect of the complexes or stalls of land which will be available once the project is completed. Such prayers shall be considered at the appropriate stage upon giving due weightage to the issue of livelihood and also duration of such occupation. Evidence in respect of such occupation shall be produced by the individuals at that relevant point of time. As the persons who are allegedly running their business need some time to make alternative arrangements, the railway authorities shall initiate drive before August. Now, my lord, what I am trying to impress very humbly before my lords, that the question which has fallen from your lordships, that whether 147 cannot be used at all, because till date, my lord, my understanding that it has not been declared ultra virus to the Constitution. The only point which is pending adjudication before the Honorable larger bench is whether 147 or Public Premises Act. Now, my lord, all the other honorable single judges, this 2024.
Have been formulated before the very
I am totally unaware, because I could lay my hands in that 2022 judgments. Then after that, I searched. I could not understand. I could not, my lord, discover rather that whether any conclusive decision has come.
What is the point which has been
Point, my lord, I will. I'm just, my lord, will allow me to use my mobile for a moment. My lord will kindly bear me.
The language is, I mean,
my lord, then I was
reported, it is reported well online. The issue was referred.
my lord, I'm sorry. Sir, এইটাই তো the which was
the reference was whether under section 147 of the Railways Act, the railway authorities can evict an unauthorized occupant of property owned by the railways without resorting to the provisions of the Public Premises Eviction of Unauthorized Occupants Act, the West Bengal Public Land Eviction Unauthorized Act, 1962. This is the reference.
This is the reference.
Therefore, 147 cannot be resorted to. That is the issue which really struck the mind of the court, and therefore it was referred.
But my lord, 2024 judgment, which I have placed before my court,
the last page is the
says, my lord, that it is intra-virus, my lord, that therefore it can be done.
Which paragraph?
My lord, last page, my lord. 70, paragraph 76, if my lord kindly comes.
So it's oh yes.
Yes, paragraph 76.
What happened to this reference?
My lord, I could not discover, my lord. After that, yesterday night when I came through this particular reference, after that I could lay my hand on this 2024 judgment which I have placed before your lordship. Now, my lord, what happened to this reference, my lord, I cannot assist your lordship.
So, Mr. Bhattacharya, what is the facts of this case? This
So
case,
there also, my lord, 147 was assorted to, my lord, evict the unauthorized persons. The court.
What was the status of those unauthorized persons?
No, they were initially, my lord, having some permission from the authorities.
Yes, my lord.
Which paragraph can you?
May I just?
My lord, may
that might get it.
You have only one.
I just want.
Please mark that paragraph.
Yes.
Paragraph 5.
My lord, paragraph 5, my lord, this is what I am trying to impress.
Please give me a
I apologize.
Please. Dhurjyoti Prasad Das was considered here.
Yes. That was considered and without respectfully will not disagree. It is referred at paragraph 63.
Paragraph
63. Reading section 147 in its proper perspective.
Yes, Dhurjyoti Prasad. And what is G. Falaguna? Which is that judgment?
G. Falaguna, I'll let you find out if it's.
These decisions have been said to be par incurium.
Yes. I would advance an argument that was probably also in the mind of judge.
Bench,
you cannot, but Justice Banerjee has committed a great wrong trying to include a word force which is not in the statute. You cannot do this. That was the view by Justice Bhattacharya, and rightly so. And this is now pending for consideration. But in any case, in my case, Mr. Trivedi has argued which really supports my cause. With greatest of respect to him, because he is arguing on my pleadings. He doesn't have any different pleading.
No. Only one thing.
147.
What is your status?
I am a rank
outsider.
Have been staying over there for last 50 years.
So, what should be the procedure to be adopted to evict you?
First of all, the
owner of that property wants to evict you. What should be the procedure?
The owner has acquiesced my stay. For the last 50 years, owners have acquiesced my stay because this is a question of housing. Article 21 comes in, he is a public authority. After having permitted me to continue for last 50 years.
Give me the permission.
No, permission, action, they say. I will show you. Kindly seize my the election.
A title by way of advance.
No. Adverse position you don't come. Therefore, Lord, here I have been staying there, Lord will see, Lord, since even in 1995, Election Commission, Lord, issued
to protect your possession, Mr. Bhattacharya, can an injunction be passed in your favor to protect your possession and that too against a lawful owner?
Lord, the lawful owner, Lord, should be restricted to be within the premises of law. I am on that.
Please show me the what provisions of law.
147 is
not be applicable.
Then kindly.
So how
kindly
come
come to
that 1971 Act?
Yes, Lordship, kindly take the trouble. Take it out. And the latest view of the Supreme Court, you have to give me rehabilitation before you evict me.
No, I will that it is under 1971.
Yes, kindly take some 1971 Act.
Yes.
The Public Premises Act kindly takes it up. এই পাখাটা বন্ধ করি।
Want that to be switched off?
Yes. Similar status, but I can't bear.
Others behind you may object.
They will excuse me for that. But kindly takes up below the section 2 of the 71 Act.
Yes. Yes.
2G.
That is
Unauthorized
the only provision which you have to rely upon. 2G, yes.
unauthorized occupation in relation to any public premises means the occupation by any person of the public premises without authority for such occupation, and includes continuance in occupation by any person of the public premises after the authority, whether by way of grant or any other mode of transfer under which he was allowed to occupy the premises, has expired or has been determined for any reason whatsoever. Therefore, the statute recognizes the situation, realities, that there are occupants who will be in the public premises. And you have to also go back to the history of the country. Because of partition, number of refugees will have to come and they had to take shelter in government lands, including the railway lines. Then kindly come to the provision, section 4.
Yes.
If the estate officer has information that any person is in unauthorized occupation of any public premises and that he should be evicted, the estate officer shall issue in the manner hereinafter provided a notice in writing within 7 working days from the date of receipt of the information regarding the unauthorized occupation, calling upon the person concerned to show cause. Now, this is a very strict provision even for an unauthorized occupant. When did the estate officer come to know? And when Milord, the estate officer was intimated they are under unauthorized occupation, initiate proceeding, and within 7 days, whether the notice. And then he has to give me, Milord, notice for hearing. Then 1A. If the estate officer knows or has reasons to believe that any person is in unauthorized occupation of the public premises, then, without prejudice to the provisions of subsection 1, he shall forthwith issue a notice in writing, calling upon the person concerned to show cause why an order of eviction should not be made. Now, that estate officer has been defined in the statute. Kindly come to section 3. Where are these? Well, the railway, Milord, cannot behave like Muhammad bin Tughlaq. He is a public authority. He is bound by the constitutional principle and morality. The Supreme Court recently said, so I'll take your worship to that. But even from reading of the statute as such, a person who has been staying there for the last 40 years will make a homeless. Cannot do this. It's a more fundamental question. That we have been saying that we are living in Jhopuri. Lordship Master had the benefit of traveling in Savan.
You are there. Do you have the particulars of the
6,000 people. I have said so.
No, 6,000 people.
But in one case,
how many structures or who have set up those structures? Because even if these provisions
these would come
to comply with,
these would come that if your lordship they have issued a notice to X or I Z, or as in the other cases they are a cooperative society or the association, they have to find out. They have to say that you are an unauthorized occupation, not me. Now, that is more important. But I can share one of my lifetime experience. In Lake Gardens, Lordship must be aware. In the Lake Gardens railway station, many settlers were there. The division bench of this court, presided by Justice Sirpurkar, directed the Commissioner of Police, go and remove them within 48 hours. Again, don't take me damage, it's a personal feeling. The Commissioner of Police met me that if we take this operation, there will be mass murder. The situation in and around the Jhopuris And the leaders who were leading the movement, they were threatening, if you do this, we will put fire on the adjacent bastis. He came and said, save us. What to do? Well, I had to meet the Honorable Chief Minister then saying, this is the situation, you have to do something. He had immediately allotted, my lord, 10 acres of land in Nonadanga for rehabilitation of these people. People cannot be made homeless like that. But we are here, he is not asking from anything. If you want to execute a project, do it. Give us time. Give us some land. That go away 500 meters from this. This is also your responsibility. Well, that's why I'm before your lordship, not for anything else.
How much time you want?
They have to let them say that you.
How much time you want?
Depending on Milord, giving them the Milord the location that you can shift there.
My learned senior friend.
That they have to come
for the cause of 6,000 people.
Yes, I am. It's a public.
My lord will kindly see the petition.
In the representative capacity, read it.
Lord, how representative capacity under civil, my lord, order 1 rule 8?
Yes,
it's not a public interest litigation. My lords will kindly see. My lord will kindly see what case has been made out by my learned senior friend's client.
Paroni to me.
I mean, Podechi sir. Please see.
This question was asked by the Honorable Court on the day 1.
Madam, will kindly see the pleadings.
Paragraph 23, sir.
Permanent resident of the locality adjacent to Brace Bridge.
Mr. Bhattacharyya, have you disclosed any of the document of the petitioner who has filed this petition?
Yes, that is full.
Where is
no, my lord, nothing. As far as nothing.
But I have saved lead. I can produce here and now. I have annexed below to one document to show that.
You have only annexed the notice.
Notice, yes.
Nothing more than that.
Yes, but I have
any document with regard to your identity.
Milord, I may. Milord, that was Milord, urgent cases. It was not done. I can immediately prepare and file it. Take it out.
What do you say to this 2G first part?
No, yes. In the voter card issued in 1995, Tikana Taratala Road, Brace Beach, Jupri. Recognized by the government. And I voted for
that card you have?
Yes, Aadhaar card. It's Aadhaar card and the voter card.
Please show it to Mr. Trivedi first.
Mr.
I don't know. I don't have any. Please, my lord will kindly appreciate Aadhaar card. My lord will have to appreciate otherwise the particular prepositions which my learned senior friend with deepest of respect is trying to impress upon my lord. In that case, my lord, the railway properties will be under occupation and no welfare project can be undertaken by any government.
And he says that shifting, he wants a separate land to be shifted there. That's one of the submission. Please kindly come to 2G once.
Lordship, I know, my lord, what's troubling my lord. The first portion.
First link of 2G.
But my lord, what I am humbly saying is.
This sort of eviction has to be
2G.
Secondly, you are right that entry upon such authority, thereafter you are in occupation after this authority expires or breach of that authority. But first limb of that.
In my case, which I am trying to very humbly make before your lordship is that the honorable division bench
is one coordinate bench.
Yes, that
has
is there.
Declared 2 decisions as per incurium. Out of that is the one which you are citing.
Which I am citing.
Has referred it to a larger bench on this question.
And 2024 judgment of the coordinate which I have placed.
2024, but did it take into consideration this? It's a reference.
Yes, Lord. It is a, Lord, even if it is taken, if it's a reference, it holds. But my lord, what I am humbly submitting before my lord, if 147 and Public Premises Act are mutually exclusive.
But that's the reference, Mr. Trivedi.
Well, that is the reference, my lord. That I also, as my lord's officer, I told my lord.
This decision says you can proceed irrespective of that Public Premises Act. It has been held to be per incurium. That's the difficulty, and I'm bound by that decision also. Please show me that 2024 decision also takes note of this 2022 decisions wherein this reference.
My lord, need not be troubled. Kindly see the latest judgment, latest Supreme Court view on railways. Three judges bench. This was a IA taken out by the Union of India for modification of the order. On the ground that a part of the land in dispute is urgently required to safeguard the railway track and Haldwani railway station. Similar is the submission. It is averred that Gaula River, which flows near the Haldwani station, after heavy rains on so and so, damaged a part of the retaining wall. The flow of the river here, I am not troubling, my lord. Now kindly come to me, Lord 3. It transpires during the course of hearing that approximately 38 hectares land owned by the railways has been allegedly encroached upon. Further, 4,365 houses are said to have been constructed at the site where over 50,000 persons are living. During the course of hearing, some video and still photographs have been referred to demonstrate the expeditious need of part of the subject land to shift the defunct railway line, besides development of the requisite infrastructure. In view of the fact that hundreds of families are living at the site for decades, we have impressed upon the Union of India and the state of Uttarakhand to undertake the following exercise without any delay. In the first phase, to identify the strip of the land which is required immediately for the purpose of shifting of the railway line or the construction of the infrastructure. To identify the families who are likely to be affected in the event of vacation from the land. The proposed site where such affected uprooted families can be rehabilitated. The basic constitutional obligation.
What happened? What's the final order on this?
This is
Because it was
this. No, the final. They have to report back. They could not yet.
it was in 2024. What happened after that?
Well, the latest position, Malay, I have to let me find out what has happened, whether they have been allowed shifted or not.
So Trivedi, this is one thing. Did the 2024 judgment take note of this 2022 reference?
My lord, that my lord will kindly come to paragraph 18, but the name is not matching. My lord will kindly paragraph 18 of that judgment of 2024.
2024 judgment.
Yes, my lord. My lord will kindly come to page 10.
Paragraph 18, yes.
And lordship will kindly see the number. This is the number of the matter which was
22570, yes.
Yes. It is 22570. If my lord kindly tallies his, my lord.
Paragraph 18 দেখাচ্ছো?
হ্যাঁ স্যার এখানে দেখুন
has a different factum also with that. Kindly, paragraph 19 gives me the support to my submission. Under such, kindly come to me the 2024 judgment, paragraph 19. Railway authorities have already allowed such persons who have been in unlawful occupation to approach them after completion of project under the scheme for license, lease, etc. in the shopping complexes, etc. There are also alternative accommodation for the shopping complex. Here, my shelter. I cannot be thrown under the sky. বাবা ওদের একটা পাল্টা পাশে জমি আছে দিতে বলো
ধর্মতলা তো স্যার আপনি দেখছেন ধর্মতলা তার রাস্তায় হাঁটার জায়গা নেই
Trivedi, now you are representing the railways as well as the state both. You are the best person to solve this.
How to solve this?
After all, they are deciding for.
Well, let Mr. Divedi take some time.
Done. Can you take instructions on this? Because there is also, look, one thing is, you take to the Supreme Court decision also. There also you may say it's an interim order, whether the ratio has.
Interim order lead to final decision.
That's one.
The intention is clear.
Officers for 30 seconds. They are saying, my lord, they are thinking of such proposition of resettling, but my lord, government of India, my lord, we need everything in inside. One officer coming and standing behind me is neither. So my lord may keep it after vacation.
Keep it after.
After vacation, my lord, and my lord, in the meantime, we will come up with our instructions. And in the meantime, I will also try to find out and discover, my lord, as to what happened to that reference, because that is the key thing.
Yes.
Because that will take care of the point which I and my learned senior friend are arguing before your lordship,
Yes,
whether
because,
mutually exclusive or not.
The latest Supreme Court law has given sanction to replacement.
Yes.
sanction
latest.
to
Replacement.
yes.
Rehabilitation.
Though it's by way of an interim order,
But
and
the latest order is that, my lord, really giving sanction to the intention of the interim order.
whether it is exercising some powers under Article 1.
No. That they did not.
That is
That will not only say that this is Article 21 will not comes.
Article 21 has not been referred to. It
The-
says
it not we know, my lord.
says, with regard to this, because it has sought for the chief secretary of the state also to sit whether anything can be done. Positive direction.
No, that's to suggestions.
Yes.
What
Suggestions, my lord,
they might say
that
that
type of suggestion, my lord,
they
may
might
also
say
pass.
that we may remove them 1 kilometer away.
What I'm humbly submitting before your lordships, in light of the Honorable Supreme Court's decision, which has been cited by my learned senior friend, my lord may pass an order.
Passing an order, you take instructions, Mr. Trivedi. I will record this. I will record the submissions of Mr. Bhattacharya and I will.
Because my two officers are saying two different things. One officer is saying that my lord, being in this particular post for 5 years, I know them as the back of my hand. Anything I have to come up with instructions. One officer is saying that we may rehabilitate them. One officer is saying there is no provision under the Railway Act. So how we can do it?
Because, you have
Yes,
to
my
take
lord.
a decision.
So, my lord, we need to take a day. I need to talk to the higher officials whether it is at all possible within the parameters of law. If possible, my lord. So, my lord will kindly adjourn the matter. We will come up with the decision, and my lord, after vacation, any day lordship will kindly fix it. But my lord, not beyond that, because the whole
No.
project is that.
That is why I have given the shortest possible time.
I'm grateful, my lord.
Because, on that date,
And that is
nobody appeared. I requested your learned junior to appear. So,
That day, what happened was, my lord, what my instruction is that they had given a notice the matter will appear on 15th, but it was mentioned and therefore, my lord, my advocate.
No.
The notice बोले थे ये लोग।
Please take
Notice
care
that.
of that. This should not happen.
When
When initially you move this, Mr. Trivedi says you gave a notice that he will move it on 15th.
Petition तक होता है ऐसे petition.
No, but they were intimated the matter will appear on 14th by through email.
Mr. Trivedi
Email,
says that
the main notice, my lord, whether
Yes, initially I am told initially it was.
my lord, it was
He
written, my
right.
lord,
Initially it was written 15, but thereafter they were intimated the matter will come on 14.
my lord, by electronic.
after mentioning.
That's true.
After mentioning that they would not know that.
So, my lord,
So
we were-
anyway, now this has become a past issue. Let us go forward.
Past issue is one thing, Mr.
Nah,
Trivedi is there, but
ठीक ना था, ठीक ना, anyway.
my lord, that is why, my lord, nobody could appear on that day.
No, she
My lord, she was here, my lord.
was there.
I asked Mr. Bhattacharya's junior to.
Yes, to sort it out. The court did not pass order ex parte. Court was very skeptic on that.
No, my lord, passing ex parte, I join issues, my lord. Passing ex parte, or if I today am called by my lord without any instructions from the railway, it is
conscious of two things.
Yes, my lord.
One is your public project.
Yes,
That's on one
That's-
side, and on another side is that's some persons will
Homeless
be
too.
displaced. So I have to decide this.
Yes,
on,
my lord,
balance these two.
yes, my lord.
So
I
for
totally
that
agree.
I wanted
That kindly
Well,
happened, Mr. Dividi as arbitrator. He will sort it out.
My lord, I am the last person.
But Mr. Trivedi is the best person
Best
because
person
he is
to-
representing the state as well as the
Yes,
railways
My
both.
lord, as of
He
now, my
can
lord,
take care of-
after some
He's the
days I will not.
He is Supreme
After some
Control.
days I will not be
Mr.
representing both.
Trivedi, I ask you in this matter, please appear.
এটা থাকবে, এটা তো।
Miss, in railways, my lord, I will appear.
Please appear for the
Well,
state.
central,
State
I-
is a party, Mr. Bhattacharya, no.
No, my lord, state is not a part. Only railway. So, my lord, in that.
Well, we may also take leave to add state so that the Supreme Court directions also. There also state was asked to appear.
Because
We will
if
add.
settlement that has to be made by the state, I think.
I will advise.
Be by the.
In that case, Lordship,
Madam,
my learned senior
I will-
friend
liberty
may,
to add
I will
the
add it.
state.
I will
my
add
learned
it.
senior friend add state, then we can bring it to a logical conclusion. Whatever falls from my lord. Otherwise, it will
আমি
become.
আজকেই করে দিচ্ছি
On
with
his
the leave
prayer,
আজকেই করে
and
দিচ্ছি
I request you to accept notice
Yes,
on behalf
yes.
of the state. Please appear in this matter for the state.
My lord.
Otherwise, in this matter,
সুবিধা হবে করে দাও
otherwise there might be a difficulty because you know this.
হ্যাঁ,
Both the
তাই তো।
authorities, if you
স্টেটকে
represent,
করলে
unless there is conflict of interest.
they cannot be
Unless there is
There
conflict of
can be.
interest.
I don't know what the state government will have to. My lord, whatever if state comes, someone we can work in tandem.
Milord, we
because
shall
some-
add state milord দাঁড়াও, আর সময় নষ্ট করে লাভ নেই we shall add state here milord issue
Yes,
notice
yes,
chief
you
secretary
issue
let
notice then.
we shall start the chief secretary so that there is no confusion
করে দিচ্ছে তো। My lord, may my lords leave.
হ্যাঁ স্টেট কে পার্টি করে দিচ্ছি তো
Can you not wait for 2
My
3
apologize.
Mr. Bhatt
I
Well,
it was passed over by a lot.
ঘুরে আসছি, ঘুরে আসছি। Let us share, my lord, for little digression and for little different taste.
Yes, yes, yes.
Because my lord,
I was talking him.
Mr. Bhattacharya does not require your presence.
Just to
Take
share
his leave.
the difficulty of typo. One day, Justice Bhagavati Banerjee called me, "Come here. What has happened? What has happened?" Justice Paritosh Mukherjee's chamber was adjacent to him. There was huge hue and cry in Paritosh Das room. I went there, কি হয়েছে কেন এরকম করছেন তুমি জানো আমি ডিকটেশন দিয়েছি দি কেস হ্যাজ এ চেকার্ড ক্যারিয়ার আর ও লিখেছে কেস হ্যাজ এ চিকেন বিরিয়ানি
I'll take a,
Mukherjee he was flying to the floor.
I was telling the same story which happened with me. We had this dictaphone, my lord will remember, in 2004-5. So I dictated before the learned district judge at Alipur. The petitioner's name was Dilip Chandra Ghosh. It came out before the learned district judge, eloper, developed chamber ghost. And now AI, Udhar Pindi Budhar Ghare will be more because computer is a intelligent fool. So this is what we have to be very good. I'm grateful.
Number 8 and 9 was fixed at 2 o'clock, at 12 o'clock today. So there's one we've settled.
Mr.
Just
I'm very sorry. I had just had a word, my junior, with Mr. Rajdeep Majumdar. He will be before my lord at 12:45.
No, sir, that's what I'm saying. No, if it could be tomorrow as to be mentioned, we've settled it. One signature is just
Settlement
required.
hoega, sir.
The settlement is done. Just one signature is required. Lordship keeps it to be mentioned tomorrow. We'll come and hand over the top.
So, my lord, this matter I was also appointed, but it has been settled. So I am a
Because of his presence, it is settled.
Because he is there.
That matter you have been appointed.
and it has been settled.
Your Lordship could just record an order, or even otherwise, there's not a.
Tomorrow we can.
Tomorrow has to be mentioned, my lord, if it just appears.
My lord,
Senior advocates are
Yes,
there. They
yes.
have not opened their mouth, so don't
but
think that.
with regards to item number 5, could be taken up when your lordship comes.
This matter also I was there. Settlement.
Mr. Chatterjee, I have not said anything against you.
I know where your lordship.
I'm coming
saw,
after
my lord.
5 minutes.
and thereafter this year.
Passover. What
Item
is
number 5 was passed over.
item number 5? Passover is
Mine,
there.
mine.
Item number 5. Yes.
But even
Unopposed.
has to
Motion
be, but
unopposed.
my problem is they've given us an eviction notice to throw us out by
Vacate.
26th.
Vacate.
Yes, if it was within the law, my lord, I would have done. I'll tell your lordship. You know, the property belonged to
Who has issued this notice?
the forest officers. Your lordship for initially directed them for hearing, my lord, if your lordship remembers. I'll tell your lordship. Below the entire land belonged to below the the Raja of Bardham. He, my lord, gave it on lease, my lord, to the Chatterjees.
Where is the notice?
Impugned order.
Notice of the order directing eviction.
135.
This is
That's the 135. And then the order, my lord, your lordship will find that at 137.
This is the notice.
Yes. Notice is at 137.
Notice is at 137.
137.
May. 26th of May.
Yes, my lord.
So you have time.
But there's no time.
26th of May.
26th of May, my lord, is round the corner and the courts closed this week.
Vacation bench you have.
No.
You have the vacation bench. By that time, panel will be.
This is completely without jurisdiction. Completely without jurisdiction. Protects me for the time being.
Mr. Chatterjee, please.
I completely bow down. I would not have even prayed for anything. This is absolutely without jurisdiction.
Yes,
Lord, it is my land on the.
Serve upon Mr. Trivedi.
I don't have a problem.
Please serve upon Mr.
But the
Trivedi.
problem is, Lord, from tomorrow there is a problem. Takes it up at 2 o'clock, then Lord, I'll serve it upon.
Why from tomorrow? What problem?
There is a problem. But from tomorrow there is a problem.
You are assisted by able juniors, Mr. Chatterjee.
No,
You may not be.
But keeps it at.
I record your presence today. I record that you have made your submissions today.
Please keeps it at 2 p.m. today. But I'll call him.
He has to take instructions.
I'll call him. He will take instructions. He will take instructions in the meantime. If not, then we shall.
Confidence.
Yes, he's a good friend. Keeps it at 2. I'll talk to him and come back to you. Because this is not completely, absolutely without jurisdiction.
What is this matter?
I'll tell you, Lordship. But the property belonged to the Raja of Bardhama. He gave it on lease, Lord, to the Chatterjees. The Chatterjees, Lord, then there was a problem, Lord, with the government. This honorable court, while dealing with that problem, said a part of the property, Lord, will vest with the government, and the other part the Chatterjees will retain. The record of rights still, Milord, says it's jungle. Now, Milord, what happens is after Milord the property vested, Milord, with the state, and some property remained with me, Milord, the Chatterjees gave it, Milord, to my predecessor. And my predecessor sold it to me, and Milord, I am in occupation of that property, and Milord, I am doing whatever business I can from that property. The forest officers suddenly say that since it's recorded as jungle, it is a jungle. You might have had had an order earlier, but no government lease is coming forward, so that order doesn't stand, and you are nothing but a trespasser and using 33(1)(a) of the Indian Forest Act.
Where is that? Says that after the festival, even if you have an order.
Yes, kindly turns to 135. looks to the first part. 135, my lord, kindly got it?
Yes.
They narrated the statement from lease agreement of 1920 to Honorable High Court verdict on such and such, but failed to produce any government order regarding lease and consonance to verdict dated. Looks to the verdict once at page 54, and your lordship will find at 57. Chup.
Sir, plot number 406.
Yes, sir.
RS and LR.
Yes, sir.
Show me that this retention and part vesting.
Yes, kindly turns to my lord. Page. It starts off from 56. And your lordship will find that at 57. CS plot number 1079, 944 and 50 acres of land lying on the southern portion of CS plot number 131 from the southern boundary line thereof of Moja and such. This will be, however, without prejudice to the rights of the petitioner to get compensation on the provision of the Estate Acquisition Act.
So you will give up, or that petitioners therein, your predecessors, predecessor,
we will give up a part and retain the other.
Give up possession of the CS plot number 1079.
Yes, my lord. The petitioners will be direct lessees, my lord. And the petitioners will be direct lessees under government in respect of remaining plots mentioned in the petition out of which this rule arises. And that your lordship will find at 59.
So CS plot number...
Well, that is what is being given up.
Yes.
And the others I will retain.
Where is the other plots? Where do I get that?
59. The schedule starts from 58.
59.
Schedule starts from 58.
So you will be giving up 1079.
Yes, brother. And retaining the other?
1079 is where?
No, this schedule is about what I will retain. Yeah, exactly. 59, kindly seize, below. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 406. They admit that. It's not that they are, yes, below. They are not disputing this. They are saying after this order, there is no government lease. And the court has declared.
You appear before the authority.
I have. I have your lordship directive.
No, I'm not asking your client. I'm asking you,
me,
Mr. Chatterjee.
But,
so you could have made the authority understand this.
My informative. I'm sorry.
33, 33-1.
Looks to 33-1. When can it be applied? Have a look at. Is one. In the question of fire, if there is a fire and if I'm responsible for lighting that fire, 33-1A comes in. This is protected forest, not reserved. So I say, my lord, it's completely beyond jurisdiction. Absolutely without jurisdiction. And basically, my lord, a nullity.
Vacating
cannot. And also, my lord, it's only with respect to if I have lighted a fire.
This is something penal provision.
Exactly. I bow down. My lord, they are taking this as penalty for lighting a fire. This can't be. This is not what I am on, my lord. My title to the property is admitted. They are saying you have not taken lease from the government. The court has declared me as a lessee.
Serve a copy, come at 2 p.m.
Or my lord protects me for some time and keeps it just after the vacation.
Give him a copy.
Very good. I'll do it.
Its order is, you have a time till 26th of
That's
May.
right.
They have requested that no order
Time till
Order in
26,
the-
your lordship knows what how it's, we don't know how it's going.
This was made to the court, all the pictures that no order, interim order should be passed or no matter, not only interim order, no matter should be taken up.
That's not fair. Then you don't do anything like this. If you in a situation where it can't be, I understand. In a normal situation, yes.
That Mr. Chatterjee, they are not appearing.
No, I am saying, my lord, in not in every matter, but there is some matters, my lord, where there has to be an interim order. They are like somebody bulldozing something.
Not that they are not appearing, they are appearing.
Yes, yes. But that's also a little weird that it's been almost 2 weeks that the entire court is stalled. That's also quite surprising.
That's for them to
But
take a call.
there are problems.
There might be some issues.
No, I know everything, but the problem is that I can't say that in court, but there is a problem. There's not a problem on that. But at times you can't stall a constitutional process.
Will it come at 2 p.m.?
I'll come at. So grateful.
Please give a copy to
I'll
Mr.
definitely.
Yes.
Thank you, Didi.
Yes.
Is that
20.
matter? Yes. Your Lordship has been hearing matters where rank trespassers are come. My lord, kindly remembers this matter from 1976, my lord.
Who was appearing?
My lord, Ms. Manoj was appearing, my lord. She was supposed to bring instructions.
Yes, very.
I am praying for consideration.
Here.
Yes, I am running a liquor shop.
Yes. Yes.
She's here. But I'll be praying that, my lord, she's disputing that I'm entitled to the consideration. Let everything come on record, my lord.
Consideration?
Consideration of my application in accordance with the amended master circular, which says that they can give fresh.
My lord, I have taken instruction.
No, not that consideration. She's disputing that. So
My lord, I have taken instructions, my lord. Firstly, my lord, in the writ petition, my learned friend has annexed a document, veracity of which is being disputed by my client.
Madam, only one thing. He wants consideration.
My lord, we will file an affidavit. No, this cannot be considered at all. We can do one thing, my lord, that proceedings under the PP Act is pending. He can apply before the state officer.
No.
Yes, that he is not willing to.
I'm not willing.
Because otherwise, directly with the railway administration, he can make any number of representation, my lord, it will not be considered because the proceedings before the state officer is pending. And my lord, one of the ground, my lord, is very severe, my lord.
Yes.
Kindly come to page 25.
Page
25 of the writ petition.
25, yes.
Yes. My lord, this document, my lord, in face of it, my lord, kindly see, my lord. My learned friend runs a case that one Sujan Chakravarti was the original licensee, and then upon
one
Sujan Chakravarti,
yes,
he was the original licensee. Upon his demise, his mother was running the shop, and then he said thereafter, upon the demise of the mother, his brother,
brother of Sujan,
brother of Sujan,
Babun was running.
Please, Babun, not Babun. There is no person called Babun. Bijon Chakravarti, according to him, was
Babun. 25 says Babun.
That is why I am coming.
Yes, Bijon.
Yes, Bijon Chakravarti was running. Now, my lord, kindly
My
come
father.
to. Yes, please. I don't interrupt you. You can argue.
Yes.
See, Babun Chakravarti, care of Sujan Chakravarti. And then, my lord, license of railway plot number such and such. If he is already a licensee, my lord, then the question of granting him a license does not arise. Who is Babun Chakravarti? Licensee of railway plot. This document is a document, my lord, which does not find place in the railway records.
Does not find place in the
railway record.
So you are disputing the veracity of
Yes, yes. These are my clear instruction in writing.
Original is.
You may have original, but how is procured, how is obtained? Because licensee Babun Chakravarti has been described as a licensee. This case is contrary to the case which is being pleaded by my learned friend in the suit, in the writ petition before Lordship. There is no whisper about Babun Chakravarti. And Babun Chakravarti was given license, my lord, as a licensee has been described, my lord. Then, my lord, there was no reason he should apply for grant of a license.
Yes.
This is one point, my lord.
So Bijon Chakraborty,
We do not know Bijan Chakravarti. We do not know anyone. We were aware by the name of a person called Sujan Chakravarti. He was originally given license for 3 years to run the stall for loose tea. Thereafter, his license was not renewed at all. He had encroached the railway areas. Proceedings under the PP Act were filed against him. Then in the year 1998, he filed a suit. And during the pendency of the suit, my lord, this document, according to my learned friend, has been given. If this document was given in 2004, my lord, he would not have contested the suit. He would not have proceeded with the suit. And if he is a licensee, then does not apply. He cannot. The question of his being applicable, making an application under the master circular also does not arise. And then, my lord, I have got all the documents to show that we have made notice against him, against Sujan Chakravarti, for encroaching the railway area. Number of correspondence. Then 98 he had filed a suit. Suit has been dismissed and appeal was dismissed in 2026. This document comes in 2004. In between.
do you have a copy of the plaint?
Plain, my lord, I have a copy, but I have not annexed.
No,
Since in
please
view
give
of
a
the
copy
fact
of the
that,
plaint.
my lord,
Give a copy of the plaint.
plain, I don't have, my lord. This was, my lord, being pursued by my father, my lord. He has expired. This is Sujan Chakraborty's plaint was there. Subsequently, in those plaints, my lord, we were substituted, my lord, plaintiffs.
In lordship, I have got
Yes,
an
who
order of
filed the suit?
Sujan.
Sujan.
Yes.
in 98.
In 98.
In 98.
Yes.
So Sujan was the original allotment.
Sujan was the original allotment.
So what was the prayer in his suit?
Suit for declaration. That is appearing from the order itself. Kindly comes to page 27.
Lordship, from the list of exhibits, we do not find the letter of 2004.
Might not be there in 2098. It is may not have been exhibited.
Madam, sir, exhibits were done when the suit was being heard in final form. By that time, 2004 had gone. You are relying upon the document.
Eviction proceedings under the PP Act is of 1990. Is
8.
So 1998.
1998.
Yes.
He challenged the notice in the suit.
In any case, my lord, how was these, my lord, as of today, even if, say, for instance, a person is illegally occupying, then also it is coming under the master circular.
It cannot.
Say, for instance, a person is, what happens? I'll tell you, lordship. Why they have not taken the recourse to the master circular for auction? They must have someone in their mind whom they wanted to regularize. That is why they have deviated from their master circular and had bought this particular circular for only 1 year, so that they can accommodate someone. Now, since I am aware of this circular and now I come and say that please also accommodate me, in spite of the fact that I am not their blue-eyed boy or girl, well, now they are coming with all this. Kindly see the master circular. Let us read the master circular first. Interpretation of
that,
the
my lord, kindly
page
see
42 kindly comes.
Maintainability.
Kindly comes, leaves away everything. Kindly comes. Say, for instance, a person is occupying illegally. Paragraph 31A, B, page 42. Of the note under schedule such and such.
31.
Paragraph 42. Kindly comes to 31A first. Kindly comes to 37 plus. Let us read this.
37.
Yes, this is the master circular which was in its original form, which has now been amended. No fresh lease and license. Page 37, Lordship is there. I am placing from paragraph 3. No fresh licensing of railway land of new establishment shops such and such will be granted. For existing shops on railway land where license has expired or not yet renewed, these shops will be auctions for grant of license at reserve price of such and such of market value of the land, provided land is not required for railways own infrastructure and development needs. However, existing licensed owner will have the right of first refusal. Now kindly comes to, and thereafter the increase. Now kindly comes to the amendment. Page 42. One-time exemption, Lordship is there. This has been substituted.
Page
42.
Yes.
This is the amended circular. One-time exemption of change in name of allotee stroke licensee of a shop holder may be permitted subject to realization of all outstanding dues, simple interest before entering into a fresh agreement with the condition that plot should not be transferred. So their point is that a person who is there has to pay money and he has to undertake that is not given away. The practice is that a licensee always gives it away. Now kindly let us read it. With the condition that plot stroke shop should not be transferred or sold on power of attorney to anyone in future. So this was the practice which was being done in all railway allotted lands. That please,
You cannot
please,
say that's
you
not
have
the
said
practice.
that. Don't.
Let him
When I am submitting, please.
Yes.
So that might have been the practice that persons are giving away their shops in power of attorney. The railway land in question should neither be connected with the railway working, not be required for railway use in near future. This is all bazaar area, so it is not applicable. Shop holder will submit a certificate that the shop is being taken on license stroke lease only and ownership of the land will remain with the railways without any claim whereof divisional authority will ensure this before entering into agreement. Fresh agreement to be entered, fresh agreement with a person who is there to be entered upon for renewal of license of railway land by all shop holders. The period of renewal of license of land shall be 5 years. Shop holders, kindly marks this. After 5 years, renewal of license of railway land not connected with the railway work can be done at the railways level with finance concurrence in terms of master circular dated such and such. The annual LLF shall be 10% of the market value of the land with annual increase of 10.
LLF?
LLF is, my lord, it is there in the master circular, that is increase of land. LLF also I have encored.
I think that's the rent or something like
Yes, what is, I'll just a minute. Kindly gives me 1 minute. I'll just search out. It's also struck me. License renewal something.
All right. Yes. There must be some charges. Yes.
Yes, charges. Now, LLF of such and such, at the time of renewal of license fee, market value of the land as stipulated under the market circular on policy of management dated such and such shall be applicable for working out the LLF. Conversion charges equivalent to 1 year license fee shall also be levied in case of change of name of shop owner. So therefore, they are converting also land license fee. This exemption, yes, 4 conversion charges of 1 year such and such. This exemption proposed in paragraph 1 above will be valid for one time availing with a stipulated period of 1 year of the date of issuance of this order. So therefore, they have consciously to regularize everything, made a deviation that whatever is there, you give us money. You don't say that the land is yours and it is being regularized. To come into this, I don't need to show anything. I need to show that I am occupied. And that will be evident from the license and the circulars, the liquor license and the trade licenses, which are standing as of today. So therefore, I show my bona fide. Give, my lord, the amount which in our calculation is 3,31,700. I give a demand draft and pray for consideration. Now it is being said that this is what happens, my lord. This happens in many, my lord. It happened also in urban development department also. Some persons to whom they want to give comes and approaches. So therefore, they make the deviation from the master circular or whatever is the policy.
And now they don't want to give that benefit to persons other than those.
Where is your representation?
My representation, my lord, is
Page 57.
57, yes. What? Oh. My humble submission is that they are entitled to give affidavits. I cannot stop them. Then let them give affidavits. Let everything come on record. And it is not that it was the case of the first case, my lord, they were using it for projects. I understand. Public interest is involved in projects. Here there is nothing. It is a bazaar area. There are several, my lord, liquor shops. What happened, my lord? My father, the husband, and my lord, the father of the petitioner number 2 was running the shop. Moment he died, the competitions arose. Now, only because I am a widow and an unmarried, my lord, person.
From bar, my lord.
No, this is fact. It is coming from record. It is not from bar.
It's all from
It is
bar.
coming from record.
Cannot be the criteria of us.
They pounce on us and now they want it back.
Are you contesting the public 1971 Act proceedings?
There is no notice after 98. So kindly, my lord, may I, it is there in my petition, let them not. If they are entitled, but kindly, my lord, not direct them to reinitiate that.
Yes, madam, 1971 Act proceedings, what is the
My lord, yes. My lord, may I come one by one, my lord, now, because he said that I should not interrupt.
No,
my lord, this is, as of today, we are in an interim stage. My contention before your lordship is that I am entitled to an ad interim stay or an ad interim status quo for a limited period. They are entitled to file their affidavit in oppositions.
But where is the threat?
Let a clarity come.
Where is the threat of disposition?
Because of that proceedings.
The court cannot give direction to pursue the proceedings.
There is a threat of disposition. Anything on
then affidavits kindly record that there is no threat of
Lord, I
disposition.
tell you, Lord.
Affidavit.
Where have you stated that there is a threat of disposition?
If your lordship is of the view that there is no threat, then kindly says that there is no notice to that effect.
Saying that show me from the writ petition that there is a threat of disposition.
No, it is not on material. No material. We have
to allege, Mr.
We have shown a bona fide by approaching.
There is one thing you have
This would have been the in all other 99 of the cases, persons would have come after expiry of 1 year, saying that there was a circular now extant. They would have sat tight over their position. It is our bona fide that I have come before the court, saying that look, my suit has been dismissed. So there might have been some kind of interim order. There was a list pendants. They didn't proceed. So it is, as of today, I am showing my bona fide by paying money. Kindly consider me.
Now,
that is all.
Firstly, my lord, question of bona fides does not arise. A person who is a rank trespasser, my lord, cannot claim equitable relief from the court. Now, secondly, my lord, the document which I have shown to your lordship, page 25. Kindly take my learned friend's document only. Page 25.
Because he is having the copy of the original document, something. What is the basis of your submission that?
Yes, I have got the written instruction. I have got the written instruction signed by the railway authorities. Kindly see, just give it. Point number 3C. I'm not making submission, my lord, orally.
Which paragraph with regard to this?
Paragraph 3, my lord. I had only one copy.
Paragraph 3.
The amendments made at para number 6 with annex P8 in the writ petition number such and such regarding the permission letter dated 4th October 2004 issued by the then senior divisional engineer headquarter as claimed by the petition. This petition release plate are denied as false. No such permission letter dated 4th October 2004 was found in office records. Accordingly, the railway does not admit the same.
No, it's one thing to say that it's not in your records. It might have been misplaced from your records.
Yes. Suppose, my lord, now.
You have not disputed the veracity of that document.
My lord.
It's not your statement.
My lord, kindly see.
That it's not a genuine document.
Now, my lord, just a second, my lord. I assume the case for instance, my lord, I accept the case for the sake of argument that this document is a genuine one, that it has not been manufactured. My learned friend must have procured it somewhere, somehow. My lord, yes. Please, I don't interrupt you. You cannot have a running commentary, Mr. Lady. This is your habit in all the matters.
No, your habit
Please.
is also there.
You please, I did not interrupt you.
Please take your seat. You are a senior advocate. Please don't interrupt.
Both senior advocates.
Wait, please take your seat.
I cannot quarrel with you.
Please take your seat. There are juniors behind you. Please take
I'll not. Now, my lord, my learned friend is relying upon this document.
Take your seat. Yes.
In the writ petition, he has come. He wants to say that the story that has been made out is this, that Sujan Chakravarti was the original licensee. He was given for license for loose tea. Then, during the lifetime of Sujan Chakravarti, my lord, proceedings under the PP Act was initiated. In the year
Where have you stated with regard to this PP Act proceedings here in your this written instructions? Where?
Yes. Point 2.
1.
Page number 2.
Page number 2.
Paragraph
yes.
2.
Paragraph 2. Yes. Paragraph 2. This is issue 2 ejectment notices. What is
Yes.
the fate of this proceeding?
What has happened, my lord? He had filed the suit. And your lordship, after the suit was being filed, the railways also kept silent. The proceedings were initiated before the state officer.
According to you,
I must tell your lordship the correct position. I cannot say something, this thing, that now, my lord, they are, because why my learned friend has filed the writ petition? Because he filed the suit in the year 1998, Sujan Chakravarti. Then the name of the legal heirs was substituted in the suit. He proceeded ex parte. Ex parte, he lost.
suit got dismissed.
Dismissed.
Now
They preferred an appeal.
your proceeding, you have initiated a proceedings for eviction.
That may not,
Unless that is taken to its logical end,
it will be,
you
it
cannot
will be
evict him without due process of.
we will, you doubt
That
that
you can-
lordship cannot, is not the
Yes.
subject matter of the writ petition. Until unless, my lord, the order is being passed, the lordship knows it very well. A trespasser has to be evicted with due process of law. The railways will not, will not take any steps, my lord, so far as my instructions are, lordship will not record it. Today, my learned friend's prayer is that, in terms of the master circular, his prayer to change the permit in its name should be considered. This is the only prayer in the writ petition, nothing more, nothing less. He is not entitled to status quo. Because if he is in position, he is in position. Writ court.
That's why I wanted you to know, if I direct you to consider, please dispose of that by a reasoned order. Say for this XYZ
No,
reasons,
and
you
the
cannot.
second, one more thing, my lord. Kindly come to the draft. The draft which he has annexed. He says he has made the payment of money. Page 64.
Page 64.
Yes.
Yes.
My lord, it can never be in the name of divisional railway manager.
It cannot be in the name of
Divisional railway manager.
this draft, Mr. Lahiri, you have deposited. No.
Yes, I have
No, you have
We cannot encash.
We have prepared.
We could
Because it is in
could
the
not have
circular.
encashed.
Madam,
The reason is not.
If you want that some fees you want to regularize, that's one
No, no.
part. He has to pay that.
My lord, he is liable to pay the damages and the wrongful occupation charges which we are entitled to recover in the proceeding. Kindly
That is
come
in
to
that proceedings.
in
You
the
have
proceeding.
not proceeded with that proceedings.
Kindly come to paragraph D, 3D.
Paragraph
3D of my instructions.
Yes.
As per existing rule of the railway, all the occupation fees for using the railway land in question will be deposited by the name of FA and CAO SE Railway Garden Reach, Calcutta 43, and not by the name of Divisional Railway. And we have not accepted the money. The draft is lying as it is. So, my lord, nothing comes on the point that he has given a draft of 3,31,700. That cannot be the issue. Secondly, my lord, if the issue remains, my lord, third issue, which is more
Why
important.
he is not entitled the consideration as
Yes,
per the
I'm
master
coming to
circular?
that.
That's the
Your
only
Lordship,
point
that
now.
kindly take the documents which are annexed to the instructions.
Instruction, yes.
He has encroached the railway areas. Apart from changing the nature of the license and a transfer of license wrongfully in the name of third party,
Which document? Which document?
from page 4 of the instruction, kindly see.
4.
From 95 onwards, we were giving him the notices.
No, he has encroached in the area in addition to which it was
Yes,
allotted.
yes. Yes.
If I've noticed, my lord, it's not within the
Yes.
within the knowledge of my clients.
It was
95
you claim right through somebody.
Petition number 2
And,
was not
yes.
Mr. Lady, there are 2 things.
Petition number 2 was not born. That's why I'm saying let this
Petition
comes.
number?
Petition number 2 was his daughter, not born.
No, you must be knowing which stall you are given. Encroachment beyond the
stalls.
area of your allotment is a different thing.
Well, I don't know what are the papers which are being given to your lordship. Because obviously, my lord, these are persons who
Their
are-
allegation you have encroached upon.
Will-
You must be knowing what was the allotment made in favor of your predecessor. So you have not encroached upon in addition to that.
If they say that this part you have encroached, there might be something that there is a counter in front of that. That might be. We will remove it. 2 stalls. That is the point where we will restrict ourselves. These are
No,
bazaar
one-
areas, my lord.
One is the encroachment and
My lord
second the
is
change of user.
My lord is if my lord has put a query to me, it is expected that you will not give the answer. I will give the answer. You have said that in other courts I do this, do that. So please also.
Don't do
So my lord,
yes,
this is a bazaar area. Lordship knows how the bazaar areas are there. This is a coal bazaar. And the bazaar in Kharagpur is it's totally, my lord, occupied bazaar. So there might have been some kind of encroachment, which according to them is encroachment. We'll remove that.
Now, my lord, kindly
But
come.
our entitlements to the shop.
Yes.
Page 7. Apart from the encroachment, the another issue with regard to the bar license.
Yes. 7, yes.
Running of unauthorized illegal bar hotel in railway plot number such and such. It is reported that one Sri Bijan Chakravarti, who is not at all licensed, is running bar hotel in railway plot number such and such unauthorizedly and illegally. It is also reported that he obtained bar license at your end for running the said business.
When did you issue the notice of eviction under the PP Act?
98.
Please give me the date.
It is mentioned in the order only, my lord. I should give.
Can you give me the date?
Yes.
So these notices are all prior to those.
Prior to those eviction notices.
So this is the cause of action for issuance of those.
Yes, yes.
Proceedings.
That is why I brought all these things.
Now the thing is that you have kept that proceedings pending from 1998 till 2026.
Because the suit was filed on
28 years, you have not done anything.
railway officers, my lord, I should say.
You have also not got possession of that property.
Yes, we have not got.
There are 2 things. One is if you want eviction, to evict him, that's one part. Other thing, if you want to after eviction to settle. So you can consider in view of this whether he's entitled to that. I'm not saying.
Well, what
You
I
have
can
to
do, my
allot
lord,
that-
as my learned friend has said, I'll use a short affidavit, my lord. Let me put all these documents on record because I'm a master circular. Benefit of master circular would apply, not in favor of persons who are, it's a general power of attorney holder they were running. These are
Say that in your order. Please say that what you are saying now, what you will be putting in your, because till now you have not, he has made a representation. You have not disclosed your stand. Please say that in your order for XYZ reasons. He
Lord,
cannot
I
be
am being
considered
told by
for his
the
prayer. Reject his prayer. Then he knows where he stands.
He knows it very well. My lord, his title in the suit has been decided that he cannot claim himself to be the licensed.
Unnecessarily, affidavits, this matter will be kept pending. You can disclose this, you can give those reasons what you will be citing in the affidavit.
I don't have any
Because
documents.
after all, he is in possession.
He is willing that he should I should file an affidavit. He is saying.
I don't have the documents. That
You
is
don't
why.
have the document.
These documents are not with me.
Yes.
Which documents?
All these documents that.
Yes, Mr. Mojumdar, only one thing. In a matter with regard to railway. So there was an eviction item number ta koto bolun to? If I'm 10, I think item number 10. Now, what happened? There was an eviction drive. Now, there's a notice not directed to any particular person. It was an omnibus notice. Now, that was challenged by one person who claims to be in occupation of that area. So now, the notice refers to two statutes. One is Railways Act 147, another is the 1971 Act. Now, I've passed an interim order. I have also extended. Mr. Trivedi is appearing for the railway authorities. Now, one thing, Mr. Vikas Ranjan Bhattacharya, he is appearing for the petitioner. So, there are divergence of opinion of the coordinate benches. Some coordinate benches say yes, irrespective of 71 Act, 147 of the Railways Act can apply and you can evict. Another coordinate bench has held those to be par inquiry. I have referred the matter to a larger bench that whether in this 147 can be resorted to or it has to be 1971 or the 62 Act. So these are the legal issues. Now, the other thing is that an order, an interim order, I must say, of the Honorable Supreme Court was referred to, wherein in similar circumstances, there was an encroachment of a railway property in a different state, not in this state. An eviction drive was being conducted for a project, for a public project. The Honorable Supreme Court was of the view that those families, because there was 5,000 or something, large number of families, certain directions were passed to locate which area, how many persons, and whether they can be relocated or settled in a different area. For that, the state and the union were directed to come up with suggestions. So that is by way of an interim order. So for that, if there is any possibility, you can come up with suggestions for that. Initially, state was not a party. So state was not a party. So I added the state as a party. They will be adding in course of this day. Mr. Trivedi is appearing.
I shall talk to Mr. Trivedi. Will
Yes,
sit.
so I'm appointing. Initially, I requested Mr. Trivedi to appear for both, but it might be because there are two different wings, so it might be a difficult thing. There might be some conflict of interests also. So he gave your name. So I'm appointing you. I'm asking you to represent the state in that matter. Then you can have a talk with, so that it can be expedited. I have extended the interim order till June. I've kept it on either 15th or 17th. You can check the 17th. 17th, I've kept it under the heading motion.
With the Lordship's leave, I have a specially fixed matter at one.
No,
matter.
Can
Can I go?
Mr. Rajdeep Mujumdar, yes.
No problem.
Deep left.
Or, my lord, I have understood what has fallen from your lordship. Lordship, we will
That
consider his
proceeding was
representation.
also in a standstill. 62 proceeding.
I know, my lord.
So that is why you take a stand. If you say for that you cannot come up with some
So we
decision
will,
so that
my lord, we will pass the reasoned order. We'll dispose of the application, my lord, dated 16th April 2026.
Yes.
Whatever the reasons, we will disclose. Within period of, because vacations are coming, 4 weeks time, my lord.
Well, they will supply whatever documents which
That
they
we
will
like,
relying
we
on.
cannot. That we cannot.
No, that is then that
How
will be
can
in
you?
violation
Yes.
of principles of natural.
You wanted consideration, we'll
want
consider.
some documents if you that's up to you.
They will supply the documents which they are relying on.
Lady, you only preparate for consideration of this. Let them. You must be
In
having the
accordance with the
documents.
circular.
Sir,
No, I don't have the documents.
what documents you don't?
1998, 1990.
You have your
don't have documents of
From someone, the basic documents you must be
basic
having.
documents which are there in the suit. I have access to that. Otherwise, I don't have anything.
When you file a new writ petition, you get it.
The petitioner
See, these are the things, my lord. And trespasser, a person who is not entitled to consideration, will not be entitled to take from us
These are
the
not the
materials.
materials, madam. These are the decision. These are not the materials. If you want to rely upon any adverse material, is he not entitled to a copy of the same?
My lord, if it relates to my learned friend, if it relates to Riya Chakravarti,
Yes,
but
yes.
so far as Bijan Chakravarti or Sujan
Not
Chakravarti
Bijan
is not
Chakravarti.
entitled to.
I said adverse claim against the petitioner.
I'll kindly record Riya
Against the petitioner, I said. Against the petitioner, seeks to rely upon any adverse material against the petitioner. I said. Yes.
May I take back the instructions?
Yes, yes. Please take back the documents. Yes.
But if I fail, then the draft will be returned.
Why shall
Want
you
to
have
take
to
back the
apply?
draft?
No,
Draft
you have
is
to
with them.
apply to go
Oh,
to
so
the.
you will take the draft.
Yes.
Madam,
We have already
because there is
one
a,
has already
there is a
been
validity
Can I just
period.
submit?
Either you encash or you refund that.
No, my lord, this
There's
is
a
the
validity
first-
period.
6
May I
months.
submit, my lord?
What,
6
what is
months
the
or
date?
3 months? 3 months. 3 months validity.
That he has to write to the railway authorities. Everything my learned friend cannot have in the writ petition. He has to approach the authorities concerned. You approach them.
You can take back that.
I'm not selling that
please
you
don't-
don't take, you give it now. But if I fail,
My lord, everything cannot be sorted out in the
you
court.
have that liberty will always.
I don't want 3 lakhs. Let them keep 3 lakhs.
We
That is
want
what
more.
I'm saying.
Wrongful occupation charges would be much more. But we have not encased it.
That is why if you say that you have not encashed it,
And we could not have. He has to write to the authorities. My lord, I cannot have any
That has
say. I
not been
cannot
considered.
make any
Yes.
submission on that.
I had personally gone and informed Mr. Trivedi Milord about this matter. He said that he would try to come, but Mr. Nilotpal Chatterjee as well. He said that if you can contact, I had gone and told him as well. Because of my urgency, Milord, I did it on my own.
Yes, where is he?
That he said that he would come, and whether he comes or not, Milord, that's up to him. Milord, kindly passes an interim order, Milord. Keeps it after the vacation. Do not pass it. Obviously, not a final. We filed the affidavit of service, and your lordship has seen, Milord, the matter. I've 130.
Give me the act.
The act. खुले दे 33(1)(a), and this is a penal provision for anybody, Milord, lighting a reserve forest.
Strategy, where is that order passed by the
54 at 57. Starts off from 54, Milord, comes up at 57, paragraph 7 and 8, and the schedule, Milord, is at 58, and our land, Milord, is at 59.
This was a compromise.
Yes. So my predecessors gave up that part, Milord, to the government.
This was by way of compromise.
And forest officials, Milord, were parties to that compromise. Your lordship sees, Milord, the earlier part, your lordship will find the forest officials were parties to that. দেখানো হয়েছে তো।
Where is the affidavit of service? Have you filed the affidavit of service?
Filed.
Affidavit of service filed in court today is
My lord, if my lord is intending to pass an interim order, my lord will kindly not, because what is happening, my lord, I am coming without knowing about the matter, my lord. And then
That's why I directed him to give you a copy.
my lord, I may have a copy, but without getting instructions, my lord. What will happen, my lord, that
Don't throw me out. I don't have a problem.
no, it is not about throwing
One
out.
thing, Mr. Trivedi, please take up section 33(1)(a). Please take up the provision 1. 33 deals with imposition of penalties.
Lordships.
33(1)(a), if you see, any person who is in a protected forest such and such shall be liable to penalty, which may extend. So it's a provision, penal provision in that way. So it does not provide for evicting a person from a property. Now please see the impugned notice at page 135.
This is the वो एक ही है
मालूम है, हम उसको यूज नहीं करना आता हूँ. 35, lordship.
Yes. Sorry, not 135, 137.
137. 135 is the order.
Yes.
35 is the
He has been directed, he has been instructed to vacate.
Lock, stock and barrel.
In coherence with section 33(1)(a). You may impose penalty if he has violated anything.
If I have
Can
lit
you
a
direct
fire.
eviction?
What I humbly submit, my lord, because nobody is appearing in this matter, my lord.
If you want, I can keep it tomorrow. Take instructions, because this is the.
Let the order remain. If there is a change, your lordship changes it. If there is anything changeable, my lord, your lordship would definitely change it. But the order is
1 day's time, my lord, let me take instructions.
Tomorrow.
Because
But
अगर आप अपीयर नहीं करो
My lord, I am appearing in person, my lord.
Yes.
My lord, I am a member of a cooperative society, housing society, where they follows the principle of each plot, each share. But my lord, unfortunately, there are rampant developing businesses going on. I made a representation before the authority on 16th April, my lord, and I have come before your lordship to dispose of the for a direction for consideration of my representation. Annexure P4 is my representation, my lord.
Have you served upon the state?
Yes, my lord. Here is my affidavit of service.
Take it after the vacation because nobody is appearing for the state. Uh,
Your Lordship, I am appearing on behalf of the respondent number 2. Here,
petitioner,
Item number
none
21.
appears. None appears for the petitioner. Is this matter after vacation? Yes, next.
I am for the
39.
239, my lord, I am for the petition. My lord, I have served copies upon all the respondents, but my lord, I have not received the status report.
Watching the entire election process. Yes.
My lord, election,
Election conducted.
but it was illegally. Therefore, my lord, several represent.
After the election has been conducted, you have to file an election.
My lord, thereafter, several writ petition was last. It was passed by his lordship. My lord, kindly come to page, my lord, another.
You have filed an election petition.
Yeah, latest petition. My lord, annexure, my lord, page, my lord, annexure, my lord, P6, page 49. Page 49.
49, yes.
Page 49.
Yes, what happened to this?
My lord, it is pending.
Yes, Mr. Naik. Why are you not disposing of this?
My lord, this is the 5th writ petition.
Yes.
Relating to that election. And
petition relating to that petition.
Election.
Yes.
Stating all the facts I have
in November, election was over.
Yes.
Board is concerned.
But if there is a dispute has been raised with regard
Dispute
to
was raised. Dispute has been not decided.
Decided.
Dismissing that dispute because they could not substantiate it.
Page 49, my lord. Kindly come to page 49.
Yes, what happened to this?
Well, let me have a report.
Yes, the petitioner
For the petition number.
I am appealing for respondent number 10, 11 and 13.
Item number?
My affidavit of service, Your Worship.
Respondent number?
The association, president
But the
and
state is a necessary party.
But my lord, state is, I have served by email. But my lord, the main problem is that the election is to be held on Sunday.
But Lordship,
26th May.
Commission of election.
40. 40.
240.
240.
Copy has been served. I am appealing for the respondent number 9.
Respondent number, yes, Mr. Naik, you are appearing.
No instruction, my lord.
No instruction, why?
No copy has been served.
You have not served copy.
By email I have served, my lord.
Email.
By email. Tomorrow? Because election is going to be held on
Let us have a copy.
election.
Yes.
No, my lord.
Yes, at 12 p.m. Lordship, this has been already done.
Election is going to be held on
The copy
Kindly see the name
of respondent number 9, my lord.
Declaration of conclusion of election process and unopposed election of candidates.
Yes. Only there were 48 Lordship person applied for nomination. It has been written and the maximum is 40.
All right, Mr. Naik, your instructions will be same. I'm keeping it today, tomorrow. Please take instructions.
A copy may kindly be served, my lord.
Please serve for me a copy.
I will serve a copy. Kindly fix it at 2 p.m. tomorrow, madam.
2 p.m.
2 p.m. madam.
Why? In the morning, what you will do?
Doctor's appointment.
Lord, kindly see the name of respondent number 9, my lord.
Name of respondent number 9.
Lord, I leave it on your lordship, my lord.
Since I'm not inclined to take up this matter. Yes.
Lord, whether they will do or not, Mr. Bhattacharya is here. Mr. Bhattacharya told that the respondents, they are raising the point of maintainability of the writ petition. If they are raising this,
you are appearing.
241. 241. Gajna. No, sir. Apnar kato.
Where is Mr. Bhattacharya?
Mr. Bhattacharya ji is there. They will raise the maintainability.
No, Ghatal.
No, sir. Gajna. Ghatal, no, sir.
But the state is necessary.
Raising the maintainability question if
Next week, Lordship.
next week.
Next week. All right.
Yes.
Not today.
My lord.
I am for the petitioner, my lord. If it can be taken after the vacation,
We are suffering from interim order. This matter was argued long back. And
Mr. Bandyopadhyay, he's
I have
waiting.
told his advocate on record.
Don't say this. My lord, kindly see, this is matter. We are suffering from an interim order. And I have argued the point earlier. This is a question of maintainability of the writ petition itself. My lord, two judgments I already just as Lordships kindly see on the same
In that
point.
case, any other day, my lord, any other day, my lord, will
Now let the
take it.
interim order be vacated. Let the interim order be vacated. No appointment.
Interim order, my lord, the state has already stayed the election process. So that is also there.
It's all right, but state will take these steps thereafter. In view of the interim order, it has been done.
No,
My lord,
no, not
kindly-
in view of the interim order.
2023 volume 4 SCC Lordships
Why
kindly
are you paying for time? What happened?
My lord,
The
kindly
only
see.
thing,
Kindly see
led
2023
by
SCC
Mr.
online.
Subhishchandra and Mr.
Just a minute.
Vikas Ranjan Bhattacharya, and
Yes, yes.
they
This
need
point
to
we have
sit with
raised
the
it.
client only for one day. That is the
Kindly
only.
come.
Was here in the morning, he moved to one matter.
He has to sit. He has to
Very
take
nice.
instructions from the client regarding a few things. He needs a
Regarding
conference.
maintainability, he will have to take instruction. Every day,
If
my lord,
it
the
can-
interim order. My lord, kindly see.
Tomorrow,
My lord.
Mr. Bandyopadhyay, tomorrow you are available.
Yes, all right.
Ask Mr. Who is assisting? You are assisting Mr. Bhattacharya.
I'm led by Mr. Subhishchandra and Mr. Vikas Ranjan
Where is Mr. Sannal?
But they will require to sit with the client for one day. That is the only thing.
Do that today evening.
Uh,
Tomorrow. An accommodation has been sought from Yes. Item 243.
Four. 44. I appear for the petitioner, my lord. I am being led by Mr. Bhattacharya. He is appearing virtually, my lord.
Yes.
My lord, item 244. This was pertaining to the election. It election. Yes, my lord, the Nondigram marketing elections, my lord. We have effected the service, my lord, on all the PSEs.
Yes, who is representing? You are representing them.
Not yet, my lord, but possibly.
Expected that you will represent, so I'm keeping it in the next after the vacation.
Very good, my lord.
But one, that was, I also, my lord, said
to get
he will be appearing on our side.
Not today, Kore.
My lord, only one thing, on the last occasion, last day they appeared, but name was not recorded, lords.
Last date, which date?
Last order, lordship. That is on 12/5.
12/5, you are there. I don't think so.
Yes, I was there, but
was there. Record করে দিন।
করে নিয়েছে।
Next. Is this matter of item number 245.
But for election commission, I appear. Ranjan Kumar Nandi.
I am for the applicant in the CAN application.
I am for the petitioner, my lord.
What, 246?
Reply.
Yes.
Here is my opposition
My lord, my reply.
to his application.
Yes. Yes. All parties are here.
For election commission, you say?
Yes, election commission, the registrar, they are there here, my lord.
Yes.
State.
State.
Actually, there is no special officer at the present moment.
There is no special officer. So what is your prayer? What do
My
you want?
prayer is this, my lord, a board has been elected, but by virtue of an order passed by the Honorable High Court, the board cannot take over the charge because an inquiry or a re-audit is pending, which was to be completed within a 3 months period of time. And that has not been completed.
That has kept in abeyance with us by an order of the coordinate thing.
No, that is regarding handing over the charge to the elected board of directors. But so far as holding of the re-audit is concerned, conducting the re-audit.
Re-audit, there is a stay.
Then no, there is no stay. In fact, they are
Why
paid to
re-audit
discharge
has
their
not been
duty.
done?
Because there is no nominated body. If you not say direct, my lord, then nominated body can be called, my lord, board can be.
So now the elected body has come. So
There is an order, my lord.
May I just place my concern? Why
who are you?
I have filed the intervention application, which is CAN 1. Now, my lord, we are the writ petitioners in the previous room. Now, the previous board, my lord, had indulged in several corruption and large-scale, widespread corruption. Even, my lord, the secretary and chairman their membership has been cancelled by the joint registrar. Now, before the last election, my lord, we filed the second writ petition. There, my lord, the order was passed by Honorable Justice Aniruddha Rai that the election process will go through, but the board will not take charge. The results will be kept in abeyance, pending the inquiry. Now, the concern is reflected in page 31, which is the order.
So charge cannot be taken over unless the inquiry is.
Yes, my lord, the reason now I am giving, my lord, and I am reading out from the order.
No, the result is not kept in abeyance.
No. They will not take charge.
Yes. Yes.
it is further clarified that if any member who shall be elected as a member of the board of the cooperative society against whom the illegalities are found by the respondent number 4, if ultimately is established in accordance with law, such member shall be disqualified to hold office of the cooperative society. So, my lord, these members who have now gotten elected, there are number of them who are members of that tainted board, my lord. Now, this was our very point in this writ petition, my lord, that these tainted board members should not be allowed to get re-elected. Now, the reason, my lord, if my lord is pleased to consider page number 7 of my application, my lord, the nature of the corruption is such that
What do
only
you
the
want?
secretary and
You
chairman
want
cannot
the inquiry to be concluded?
Yes, my lord. I also want the inquiry to be concluded. But these tainted members should not be allowed to take charge, my lord. Because there
Yes,
will
sir.
be
How
destruction of
soon the
evidence.
inquiry can be concluded?
May I submit, may I submit my lord? one
as
moment.
regards the election of the board and my lord asking them to function, what's the problem? Kindly my lord, come to page 30.
Page
30.
30.
That's the order of the coordinate bench. Also kindly come to that. Page 30, my lord, third paragraph.
Yes.
This is the my lord crux of the my lord observations, whereby everybody my lord rested. The cooperative society shall proceed to hold the election as scheduled on
30.
August 24, 24.
My lord, of the application, my lord.
Oh, of the
It's an
application.
Yes, application. Sorry. I'm sorry, Lord. Can one. And shall also publish the result of the election, but such results shall not given any effect until the irregularities and mismanagement as held by the respondent number 4 in its recent decision dated 22nd June 24 is totally redressed. The result of the election shall be kept in abeyance, the record of the respondent number 4, but in abeyance. So, my lord, the problem is the mismanagement as held by the respondent number 4 in its recent decision dated my lord, June 22nd, 24 is totally redressed. The area, it's a vast area, my lord. This requires some sort of clarification. I do not know why the parties were not, my lord, was not pleased to my lord, take out the election petition for clarification of this. It is covering each and every, my lord. Anybody can say this is irregularity. So what are the specific issues? Those issues may be redressed. Otherwise, it will never be redressed.
May I submit,
And
my
never the board will come into the
May I submit, my lord?
One thing.
function.
Then next paragraph.
Yes,
Special
ma'am.
officer is
Already appointed.
To take the assistance of the probe into the
audit
Yes.
directorate too.
So what happened? Who is the special officer is
And
not
kindly turn to next page, my lord. It is
Yes.
and the said audit investigation in every respect shall commence and shall be completed positively within a period of 3 months from the date of its commencement. And it has not been done in spite of 1.5 years, almost 2 years, my lord.
take out a contempt application then if it has violated that order.
Now, I was not a party, my lord. What I am suggesting is this, that I am not in way of, coming in the way of the.
May I put forward a suggestion, your lordship, subject to your lordship's acceptance? If those persons who have been elected in the meantime may take the temporary charge of the society,
How can it be done?
No, what?
or else your lordship,
Cannot be done because there is an order directing them not to
or
take charge.
or your lordship may appoint.
Inquiry, why the inquiry is not been concluded?
Your lordship, the audit is writing letters again and again, but the special officer has no power now. So we need the documents to be supplied to us. So your lordship may also appoint someone from the court to go and hand over these papers to us so that the audit may be completed in the meantime.
No.
This can be.
This will not solve the problem. Kindly see, the audit
Then ask
officer,
if he has a solution.
officer was in charge and he didn't perform his duty. And kindly see, my lord.
Now in the present situation.
Done. Now it is to be done.
So kindly,
So how this can be done?
kindly come to section 29, subsection 7, my lord.
Yes. Cooperative society is accepted. Cooperative society. Yes.
Section 29, subsection 7, ma.
Yes.
Lordship got it.
Yes.
May I place it, ma? If the election as referred to in the third proviso
subsection 1A of section 35 or in subsection 2 of section 36 cannot be held owing to an order of any court or for any other reasons, or if the directors of the board elected in a general meeting cannot function owing to an order of any court or for any other reason. Here there is an order of the court, my lord, honorable court, and the elected direct cannot function. Or if the elected directors of the board resign simultaneously, the registrar may constitute a board of directors from among the members of the delegates or representatives of the cooperative society in conformity with section 32, and the constituted board shall elect its office bearer from among themselves, provided that the board so constituted shall function till the directors of the board elected under this section assume charge. So what I suggest, my lord, that let a nominated board be constituted by the registrar within a specific period of time from the members who were not members of the previous board. So the grievance of the original writ petitioner will not be hampered. So the order is not flouted of the honorable court. Let a elected board be there, nominated board be there, because the specialist officer is not functioning. The electricity bill is remain pending. The property tax of the NKDA remains pending. The regional generation set is rotting. Security services is
the only way.
saying that I will not, we will not
say. If those tainted members are not allowed to take part,
Well,
do not have any grievance
to
there.
that I will not have any grievance.
Yes, direct the registrar to
Yes,
elect a nominated
That's the
board.
prerogative of the register, lordship.
Yes, who is for the register?
My lord, I appear.
So you constitute a
Nominated board. Within
terms
7
of
days.
this, but don't include any of the.
Yes, ma'am. Any of the members who were directors in the previous board. We are agreeable to that. And my lord, along with that, kindly pass also a direction to conclude the inquiry within a specified period of time. No further delay.
Let the nominated board be first constituted.
My lord.
Yes.
May those names be recorded in my lord's order. The names may be recorded in the
Names of whom?
those directors, my lord. There are,
That the registrar will constitute that.
5 in number, my lord.
Register will constitute that.
I'll clarify, not amongst the elected members
Yes,
or those who are in the previous.
The previous. Yes.
Not amongst them.
Yes.
The inquiry. My lord, I have prayed for intervention in the writ petition.
You have prayed for intervention. No, in the writ petition to.
In the writ petition, I have prayed for direction, my lord, so that the elected board can assume charge and conclude the inquiry.
So I'm directing the audit to be concluded after
Yes.
constitute a nominated
Nominated
board and to conclude the audit within the specified time.
Audit investigation within a specified period of time.
that ultimately the outcome of the inquiry, if somebody is found tainted, he or she shall be deemed to not eligible to hold office, my lord.
That is
Because
already
because
there.
that was there,
That
my
is
lord.
already
That is
there.
the consequence.
That is already there.
That is in the
That's
act
the
itself.
That is already
consequence.
there.
Kindly
That
indicates,
remains untouched.
my lord,
Yes.
kindly indicates, my lord.
Yes.
Otherwise,
the
my
next
lord, it will
matter.
be a
Yes,
dynamic
ma'am.
matter.
Yes.
Yes.
Item number 47, I approve the petitioner being led by Mr. Bhattacharya, my lord,
Yes.
virtually.
Yes.
But this pertains to that election which, despite an order of your lordship,
Yes. It has been
the
done now.
it has been now done. Election has been very successfully conducted, and the petitioner and his supporters, my lord, they have all been, my lord, winners, my lord.
Yes. Now, what do you want to do with this matter?
I think nothing remains, my lord, since election has been conducted. Only, my lord, that aspect, the SP, the conduct of the SP. My
Yes.
lord had kept it pending.
Who will defend him?
Mr. Bhattacharya himself.
So Bhattacharya, who will defend him?
The SP should come before the honorable court and defend himself.
Yes. Who will assist the
Who will guide him?
Yes. Yes. I can direct the
That
appearance.
is,
So Bhattacharya, if
my
you
lord, may kindly direct, my lord, the appearance, because but orders of the court, my lord, should be acted upon with utmost seriousness, my lord. There should be a message loud and clear.
My lord, here, may I submit the report, Lord? Lord, voters were 708. Now participated 511. And, my lord, 49, my lord. That's the case.
the learned advocates for the
Mr. Bhattacharya will add. Item number 248.
In view of the order passed in
Which is
view
pending.
of the order passed in 8579 again.
Our submission was that, my lord, after disposal of the writ petition, no application can be filed, my lord.
Closed off?
Dismissal, my lord.
Yes. Call the next matter.
Grateful to your lordship.
My application. It arises out of contradictory stands taken by the competent officer, competent authority under the West Bengal Apartment Ownership Act.
Date is there after vacation. Yes, or not today. Yes, next.
Kindly provides me a date, my lord. It is
It
possible.
will appear in the after vacation. Yes. Next.
Mrs. Boishali Ghoshal is appearing for this matter.
Not today. Next.
Not.
251.
Yes.
Then why the 1013?
Not today.
Petitioner is there though.
51. 51.
52. Not today. 53. Not today. 4. 5.
After the petitioner one.
Yes, not today. Next. 9. 1. 5.
269, I'm appearing on behalf of
Petitioner.
respondent number 3, 4, 5, 8,
They are
and
the
9.
answering respondent, my lord. They are the answering respondent.
Yes, 269.
Yes, the bank.
Who are they?
The bank.
Bank authority.
Bank.
Bank.
Malda District Central Cooperative Bank.
Yes, what is this matter?
Yes. But the petitioner before your lordship, he was appointed as a special officer in a
269. State is presence of state is not necessary.
as of today, my lord, the bank would be the and main answering respondent before your lordship.
But the state appeared.
Yes, they appeared.
Mr. Naik.
Yes, Mr. Naik is appearing for.
But the state. Yes, what is this matter?
Yes. But the petitioner before your lordship was appointed as a special officer. Your lordship would be finding that order at page 25.
What are you challenging?
We are challenging an order of suspension. As of today, my lord, they have initiated a DP, my lord. I am seeking a stay on that because the decisions which are now to be tested before your lordship, those decisions were not unilateral decisions. The decisions were made in the presence of all the representative of the cooperative department as well as the bank. Now the bank says that you have taken a wrong decision. The decisions taken by you, you could not have taken those decisions because no power was vested in myself. Your lordship kindly sees page 28 for once.
Page
28. And this is an order dated 1st of March 2024. Your lordship would be finding 4 names in these columns. Kuntal Das, Abhishek Mondol, Pulok Haldar, Devashish Kundu. Lordship has got the names?
Yes.
And Abhishek Mondol was a signatory to all the decisions in which now I am being penalized.
No, which order you are challenging?
Yes, yes. But this is the inquiry order and your lordship would be finding the order of suspension at page 48.
48. Yes, have you disciplinary proceedings has been initiated?
Maharaj, the order has been passed for initiation.
Yes.
And this order is after the filing of this writ petition.
Yes.
Now, your lordship kindly comes to page 28, my lord. And this was the preliminary report.
I can direct the inquiry proceedings to be concluded within a certain time.
But my case before your lordship is persons who were party to the decisions now on a malified basis is trying to initiate a proceeding against me, my lord.
You have this memorandum of charges have not been served.
No.
Take all those points.
My lord.
All those, if disciplinary proceedings is in contemplation, Can the suspension order
But
be
kindly,
set aside
kindly, but,
or stayed?
but kindly,
Not be allowed to participate in the, you'll be entitled to the subsistence.
I know, my lord. But kindly have a look to page 28 for once.
Page
28.
Yes.
This is the preliminary report, my lord.
Yes.
You
Those are on merits. So now you are challenging the order of suspension.
Yes.
So order of suspension was passed on 5th of September 2025.
Yes.
So
but kindly,
giving
because,
the subsistence.
but this report has a nexus with the suspension order because your lordship would be finding 4 names in this page 28. Abhishek Mondal was a signatory to my decisions. Now kindly comes to my lord, page 30.
Yes.
At paragraph 6. Last paragraph.
Yes.
May I place my lord? In the calendar year of 2022, Dhammoer Bahrampur SKUS planned a milk processing unit with a project cost of rupees 26 lakhs. As a result, a loan application for PMEGP project under DIC of Agro and Food Loan application was submitted at Malda District Central Cooperative Bank Limited. The application was approved.
You are holding which position?
I was at that point of time was a special officer. As of today, I am no longer the special officer. So my decisions as a special officer now are being penalized or sought to be penalized.
Yes. So now the proceedings, they have contemplated an initiation of a proceedings. So if the memorandum of charges is served upon you,
when the person who is issuing the memorandum of charges or in fact has issued the order of suspension is the person who had approved my application. The person who has prepared this inquiry report.
That is the ground for getting exonerated. You will be successful in the disciplinary proceedings matter.
Very good
ground.
When the suspension order issued by a person who has a direct nexus with the outcome of these proceedings, my lord, your lordship's court has already held in a number of cases.
Let them file affidavits then.
But only one
question of
yes.
passing
But the only interim order that I was seeking that
that is in the nature of the final order.
No, the interim order that
suspension order, what you have paid for setting aside. So if that is stayed now, what is the effect? What remains to be decided after affidavits?
What I'm saying that now they would be initiated the DP, my lord, the disciplinary proceedings.
That can be initiated. That has to be initiated.
Yes. But no final decision to be taken without leave of this.
That they have not yet initiated. You can come with a prayer. Final decision is long way to go. Prior to that, you can get it set aside.
My lord, kindly see page 11, my lord, paragraph 16, my lord.
Yes. There are two ways. If you want the disciplinary proceedings to be concluded within a time, I think that's better. Otherwise, it will be kept pending. I can direct that disposal within a certain time, expeditiously.
Can I come back with instructions? Can I come back with instructions?
The petitioner.
My lord, the application is for expeditious disposal of the main matter. My lord, the reason we were constrained to file this, my lord, the petitioner is a cancer survivor. He's fighting cancer, my lord. His condition is worsened now. But I'm only praying if a date be fixed post vacation, I'll indicate, my lord, the point. My lord, this point is that there was no board of directors. A lot of facts. I'm not going into it. The point of law is this: no board of directors, my lord, and a special officer. My lord, when there's no board of directors, special officer has initiated the proceeding. A judgment of coordinate bench, my lord.
Initiated proceedings for what?
Disciplinary proceedings, my lord. Show cause and then a disciplinary proceedings. After some 9 years, my lord, they have passed an order. And this is pursuant to a direction because they were not passing any order. But we had approached the Honorable Court. The Honorable Court said 7 days complete the proceeding. 7 days does not mean, my lord, that they would give us anything. They have not given us. I'll indicate that. And also, my lord, the point of law is this, that when there is no board of directors, the special officer is not vested with, my lord, any right to initiate or proceed with the proceeding. My lord, I'll give the judgment. In fact, if my learned friend also considers that when it is taken up by your lordship, this judgment is what we are relying on, paragraph 18 onwards. I'll quickly hand. Paragraph 18, the analysis starts from paragraph 17, page 9. I am relying on the proposition from paragraph 18, page 10.
Yes.
In the present case, the suspension order identified the petitioner as a public servant within the meaning of section 21 IPC and also in accordance with provisions of section 10 of the Act of 2006. Thereafter, by invoking Rule 106 of the Rules of 2011, a memorandum of charges was issued against the petitioner. Uncontroverted statement of the petitioner indicates that the service conditions of a bank employee are governed by the said Act and rules. I pause here for a moment, my lord. Very interesting. In this matter, the same person is involved, the same rules are involved. In fact, the same person is involved, my lord, for the bank, the special officer. Therefore, West Bengal Cooperative Societies Act, West Bengal Cooperative Societies rules are the relevant statutes governing the disciplinary proceedings and shall govern the field in this matter. Paragraph 19. Undeniably, paragraph 15(1) of Rule 106 of 2011 rules specifies that for purpose of imposing any penalty, the board, which is the appointing authority, shall be the disciplinary authority, and the general body of the members in the general meeting shall be the appellate authority. Annexure 3, affidavit in opposition filed on behalf of bank reveals, upon expiry of tenure of the previous board of directors, one Jitendra Shaw was initially appointed special officer to discharge functions and responsibilities of the board. Over the page, my lord. His appointment was thereafter periodically renewed, meanwhile, by a notification. One, Partho Sharoti Devnath. I pause here. This is the same person, my lord, who is in the present matter, who is a special officer, was appointed as the chief executive officer. Even now, my lord, he is the chief executive officer of the bank with authority to exercise such powers and perform such duties as prescribed under the Act and rules and bylaws of the bank. Paragraph 21, section 29(8) of the Act provides that if the board of directors cannot function owing to an order of court or for any other reason, the chief executive officer of the cooperative society, or where there is no chief executive officer appointed by the state government or registrar, the highest designated employee of the cooperative society shall manage the affairs of the cooperative society till a board is in position to function. As previously noted, the board is the designated authority empowered to initiate and take disciplinary action within the bank. The role of a special officer is generally confined to managing the day-to-day affairs of the bank society in circumstances where the board is unable to function or stands dissolved. The mere appointment of a special officer does not by itself vest in him disciplinary powers ordinarily exercised by the board. In section 33 of the Act of 2006, the legislature has employed the phrase to manage the affairs of the cooperative society. However, section 32 of the Act does not contain any provision specifically dealing with the initiation or exercise of disciplinary action against the employees or staff of the society. The next paragraph, my lord, over the page. Admittedly, Rule 106 of 2011 rules and appendix to Chapter 5 contain provisions relating to initiation of disciplinary proceedings, disciplinary action against the staff of the society. In paragraph 15(2), it was specified that an appeal shall lie against order of the CEO to the chairman of the board. However, it has not been expressly provided that in that situation, when the board is unable to function or is dissolved, then chief executive officer referred to in the paragraph assumes the power of the board to take disciplinary action. In the present case, neither the petitioner nor the bank has placed any material on record to show whether internal service regulations, namely Bhatpada Noihati Cooperative Bank Limited Regulations 2009, or any other statutory provision, enactment, or rule addresses the issue of delegation or assumption of disciplinary powers by the special officer or the chief executive officer of the bank. Exactly my case, same rules apply. My case is this officer had no right, no jurisdiction, and hence the impugned proceeding has to fail. No appeal preferred against this order, my lord. We have checked that against this judgment and order, my lord. Let them indicate whether this has been overruled, my lord, in appeal. Because we have checked, my lord, this is not, because they are party to the proceedings. And then, my lord, paragraph 24. And 25 also, my lord, list of documents are not given in that case. In our case also, we'll show, my lord, the various documents which we had called for it was not given to us, my lord, in the course of the proceeding. But this is the crux of the matter. I'll show 2 pages, my lord. My lord, page 127 of the writ petition. The serving on the other side, right? Evidence of service. This is a vote.
One thing. If there is no board or the tenure of the erstwhile board has expired, special officer, then nominated board and other things. In the meantime, there is some disciplinary matters come or some employees charged with some offense of that. So he can go scot-free on that.
No, my lord, there has to be a, I'm sorry.
What can be done in that situation?
There has to be a delegation, my lord.
Who will delegate?
My lord,
Who
because
will delegate?
there is, the rule is silent on this. The lord,
So who will delegate? So nothing, who misappropriates, no suspension, he will carry on with those, he will destroy the evidences.
and I'll show, my lord, from the
Very
record.
difficult to
My lord, I'll show from the records.
My lord,
in
this
the
disciplinary
9
proceeding-
years,
this
my lord, I'll indicate the facts. I've not gone into the facts.
The disciplinary proceeding was
Lordship, lord.
the fact
9 years
that
later,
special officer do not have the power to initiate a disciplinary proceedings.
my lord, that's my case.
That's the point of
That's
law
the
which
point
you are
of law,
trying
my
to
lord.
argue.
Indeed, my lord.
Now, special officer takes charge
Lordship.
when the tenure of the erstwhile board has stood expired or it has been.
and the special officer is vested with all the powers of the board.
So now, let us take a hypothetical case.
Lordship.
So the board is not there. So board is the authority to take a decision on initiation of a disciplinary
lord.
proceeding. Now, board is not there.
Administration.
Special officer has been appointed.
Lordship.
Now, the special officer cannot also conclude the
Lordship.
proceedings for holding elections within, I think, 6 months or so, his tenure. Then another special officer, he also cannot do 2, 3 special officers.
The CEO, my lord, CEO of the
Then
cooperative.
CEO, highest paid employee, he
He's not.
can come in, nominated board. So these
He can't. That's my
So,
case. He
yes.
could not have done.
So these are the things.
My
Now,
lord.
in the meantime, an employee
I'm very grateful.
defalcates,
My lord.
misappropriates, he goes. So evidence says if he is in charge, because what is the why an employee is suspended? What's the necessity? Because the employer has also to pay subsistence allowance
Lordship.
without getting the services of that suspended
Employee.
employee.
My lord.
So it goes out of the exchequer of the company.
Lordship.
And then he has to pay, keep that employee out of those service. Why?
My
The
lord.
purpose is so that he does not destroy those evidences, and so
Indeed.
that's the object.
Indeed.
So if nobody is empowered, he goes scot-free. Is it the object of the statute?
Can't be, my lord, because 2013 is when
You
the
have the
proceeding
Municipal
happened.
Act with you.
Yes, my lord.
Yes.
You have the West Bengal Municipal Act.
My lord, 1 minute, my lord. My lord, 1 minute, my lord.
Cooperative societies
This,
act, my lord, we have.
this disciplinary proceeding. My lord, can
Societies Act I
this,
have.
this disciplinary proceeding,
You have a copy of the Municipal
this
Act.
disciplinary proceeding was
West Bengal
challenged.
Municipal Act.
Not immediately, my lord.
This disciplinary proceeding was challenged in the early writ petition.
Yes, because it was
Just-
2013 onwards, they had not
Earlier
passed
writ
an order.
petition was
My
disposed
lord,
of.
what fell
Actually-
from your lordship is, my lord, at this point when the change happened, when there was no board, but this was going on from 2013. Now, suddenly, my lord, it's not that there was
Yeah.
no board from 2013. And they were
My lord,
called
anyway,
up,
my lord,
my lord,
I
to
have been,
show what
my lord, I have been engaged, my lord, a few days back, my lord. I find, my lord, there is a direction for filing affidavits. My lord, I have prepared my affidavits. My lord,
They
kindly
filed
give
in
me.
opposition.
No, no, no,
আপনি
no, no,
file
no,
করে
no, no,
দিয়েছেন।
no, 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 no.
আপনি
কোথায়?
ফাইল করে দিয়েছেন।
কই?
এফিডেভিট ইন অপোজিশন
দেখি,
আমাদের
দেখি,
কাছে আছে।
দেখি।
এই-
আমার কাছে কোনো এই নেই।
এই তো আপনি না can't see you
No,
file.
no, 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 sorry, I'm sorry. আমাকে যা কপি পাঠিয়েছে bank
No, no,
থেকে।
I understand.
I,
But may I file?
no,
the
there was no
affidavit in
board.
reply also?
Special officer there. After board has come, my lord, I have been briefed. I
আপনি
don't
সব
find
file
any.
করে দিয়েছেন।
I don't find any
আমরা
document
দিয়ে
with me.
দেবো
Yes,
আপনাকে।
yes.
But
I
may I
don't-
file the affidavit in reply and the affidavit of service?
You can file the affidavit in reply.
আমার কাছে কোনো document নেই।
বুঝতে পেরেছি ওই জন্য।
আমার draft করা হয়ে গেছে। I have drafted.
সব ফাইল হয়ে গেছে।
হ্যাঁ, একটা কপি
This is
আমাকে
ready for
দেবেন?
hearing, madam.
এটা দেবেন? আচ্ছা, ঠিক। দেখেছো? সুন্দর।
এটা দেখে নেবেন এখান থেকে আপিল হয়েছে কিনা আপিল হয়নি
ওটা দরকার নেই।
কল আপন হয়েছিল
ঠিক আছে make it sufficient. Make it sufficient.
I will.
I'm sorry, yeah.
No.
I'm done.
Because the special officer here, they will perform, or he will perform,
Kindly see section 36, my lord.
yes, 36.
Perform all the duties of the board.
Yes, shall manage the affairs of the cooperative society.
Kindly see the proviso, my lord.
Managing the
That's what has been interpreted. Day-to-day affairs.
from amongst its
4B,
officers
4B.
for managing the affairs of the cooperative society.
Very grateful.
So, what does it mean?
Paragraph
Managing the affairs of the cooperative society.
Kindly see section.
does not
My lord,
mean
kindly see
vesting this
4B.
officer.
Kindly
A very
see.
respectful submission.
I can say 4B.
Vesting this officer, my lord, with a power to initiate a disciplinary proceeding is what has been held in paragraph 22 and 23. My lord, paragraph 22 and 23.
I'm asking you, if that case remains,
My lord.
so that employee, everyone can.
He goes
be
scot
appropriate.
free. He goes scot free.
Then in
What
my
is the
very
meaning of the expression managing the affairs?
managing the
Is
affairs.
it such a thing that only the day-to-day activities, nothing?
My respectful
Who will
submission,
run?
my lord.
No.
It should be. I understand what is falling from your lordship,
Yes.
my lord. It then should be, my lord.
It's a dangerous proposition, what you are saying.
My lord, I am not saying that this has been held by the honorable
That
court.
is,
Lord, I'm only my lord espousing and marshalling
because,
that.
please consider
Indeed.
this, because nobody will be in charge. Board is not there. There may be, there are things where there is no provision or the forum of appeal.
Lordship.
Maybe you are saying that there's a forum of appeal, so appeal lies before such authority, that will not be there. It's a different thing altogether. There may be a case that where there is no forum of appeal, you can challenge in the writ. So that does not take away the power that no, since there is no provision for appeal, no disciplinary proceedings can be initiated. That cannot be the law.
But here,
So then that proposition would lead to a conclusion that during the time there is no board constituted, no disciplinary proceedings, nothing. So it can go on in that way.
but may I indicate this?
My lord, kindly
This is the, in fact, on merits, I'll show other things also. My lord, absolutely non-speaking order. I'll show that. That's all on merit. And not only on the law. Indeed.
If the
Only the
jurisdiction part,
Lordship.
My lord, kindly see section 4, section 36,
Before my
4B,
learned friend
4B,
makes
4B,
any further submission,
4B. My
there
lord,
is
kindly see
a
4B.
paragraph in this judgment,
Kindly see
paragraph
4B,
23, that
4B.
the parties were
36,
called,
4B.
the parties were called upon
4B.
to not indicate any part of the regulation
Subject to the control and direction of the
which they
district
failed to.
and
Paragraph
notwithstanding
23.
the preferring and appeal, under supported the special officer shall exercise all the powers and performs all the duties which may be under the act or rules may be exercised by the board.
Yes.
That is,
And that's what, my lord, my contention is.
and my lord, kindly
would be
see
the day-to-day affairs.
But kindly see page 288.
Board of directors do not have, my lord, the right to initiate a proceeding.
Where is bar? Where is the bar? I don't understand this. Where is the bar in the law?
I give you
under the law,
No.
who can initiate the proceedings?
Lord, this is
Ordinary case, who can initiate the proceedings?
the board of directors when it is in session, my lord.
Yes.
When it is there.
So, if the board is not there,
my lord,
then there cannot be any initiation of a disciplinary proceedings.
For the time, it's a very temporary measure.
What does the special officer do?
The day-to-day affairs of the company or of the cooperative society would not include.
What does it mean, day-to-day affairs?
So the everyday affairs of the cooperative society, which would not include.
So it will
Everyday affairs will not be defalcation of any.
Day-to-day affairs means carrying on the duties in ordinary course of business. So defalcation or anything.
It can't be an that's my submission, Milord.
Would be in ordinary course of business. Someone who has been entrusted to do something. So he does that in his ordinary course of performing the functions, does certain acts. There were nobody to manage that.
Termination per se would not, in my very respectful submission, be a ordinary course of business. Is a termination of an employee, which was pending from 2013. 9 years later, they pass an order. 10 years later. 10 years later, they pass an order. They sit tight over it when, the board of directors was there of the cooperative society. It is not a case where 2013 onwards, there was no board of directors. Board of directors was there. It is only, if your lordship takes a page 341, volume 2 of the writ petition. Since September 2020, there is no elected board of directors in the bank. First line. And this is a letter of the cooperative bank, page 341, of the petition. Volume 2. So from 13 to 20, there was no impediment for the bank not to conclude this proceeding. If it is
not a credit structure entity.
No. No, Milord.
Not a credit structure entity.
No. And the inquiry report is filed on 28th of November 2022. After filing of the writ petition during the pendency of the writ petition.
Was issued by the chairman.
By the chairman, Milord.
Yes. So there is no difficulty on the show cause notice. So where is the initiation of the disciplinary proceedings? Where is the memorandum?
So the memorandum of charge is page 41. Volume 1, page 41.
Suspension order is also by the chairman.
Lordship.
So no difficulty.
No difficulty.
And this is by the chief executive officer.
My lord.
So there is also no difficulty.
Chief executive officer cannot. That's my case. Also, my case on merits is different. My case on merits, I'll indicate, my lord, that this is absolutely non-reasoned, non-speaking order. Unreasoned
why
order.
The chief executive officer cannot do that?
Not because chief executive officer, my lord, is not vested with a power. There's no delegation of power, my lord.
Oh, chief
to the CEO,
officer,
lordship.
Yes. So,
15.
Who is the appointing authority?
The chairman. My lord.
Appointing authority is the disciplinary authority.
Yes, my lord.
So who is your appointing authority?
I'll cross check, my lord. Should be the chairman, but I'll quickly indicate, my lord. Kindly grant me a moment.
So if the chairman, the chief executive officer
is not the chairman,
the rank below the chairman,
he can't.
Appointing authority is the board.
It's the board. It's the board, my lord. I stand corrected. It's the board.
Appointing authority is the board.
Authority
is the board.
Appointing authority and disciplinary authority is the
Then
board.
principal
And
applies,
board
my
has
lord.
appointed chief executive
So
officer.
then they can't.
So in that case,
My lord.
who would be the appellate authority?
The board is the appellate authority, my lord.
Board is the disciplinary authority. Board is the appellate authority.
My lord, kindly see, my lord. That's why.
How can it be?
That's, my lord. We have
According
indicated.
to you, board is the disciplinary authority.
My lord,
board cannot be the appellate authority.
we have. This is a reply given by them. Kindly grant me a moment. I'll indicate that the document is on record, my lord, where we have stated who. Let us know who is the appellate authority, and this is their reply, my lord. Kindly grant me one moment. Where is that document? The letter by which we made that request is page 128.
128.
Volume 2, my lord.
Yes.
And the response given.
So what information you have sought for?
My lord, the appropriate appellate authority, we needed to know, my lord, who is the appropriate my lord, authority for appeal. Lordship will kindly note the letter of 30th November 2022, my lord.
Yes, yes.
Prayer for information regarding appropriate appellate authority.
Yes.
The first page, my lord. The response is 129. In terms of your letter, you are hereby informed that the appellate authority will be the general body of members in the general meeting in terms of provisions 106.
The general body members is the appellate authority.
Yes.
He has to
General
prefer
body
an-
members.
He has to prefer an appeal before the
No,
general
body
members.
members.
Yes,
My
not the
lord,
board.
stand corrected. General body
Not the board.
members.
Yes.
My lord.
So there is no difficulty. General body of members is there.
Is the appellate
Appellate
authority.
authority is also there.
It was not there. That's the
Now it is
difficulty.
there.
It's not there. my lord.
General body of members is not there. What are you saying?
It was not there. my lord. That is the reason we did not
General
have it.
body of members is the all the members.
My lord, when the board is suspended, my lord, when the there was no board.
General members will be suspended.
No,
What
my
are you
lord.
saying?
No. I'm not
Board
saying
is
that.
the elected
I'm not saying
board.
that, my lord. The
So-
board was not there.
Yes.
When the board was not
So
there,
the
my lord,
appellate
the appellate
authority is there. So appellate authority is there.
Your lordship will kindly take up once, my lord, page 130.
130, yes.
Kindly see, we have addressed it to the general body of.
Yes.
Now kindly see, my lord. The subject, I have received a letter issued by the chief executive officer
Please show
whereby
me
it has
the,
been informed.
Order of the disciplinary authority, please show me that.
Lordship.
Yes, page 127. Is it page 127?
Starts from 105, my lord. The note sheet is there and then 105 onwards, my lord.
So is it the ultimate page is 127? Please check up.
Madam. Yes, the dismissal. That's the dismissal order, my lord. That starts from page 125.
My lord, make
That's the
127.
letter of dismissal.
Yes,
127 is the operative part of the dismissal order. My lord, the second last line is important. The entire decision has been taken by the special officer of the bank. Vide his note sheet dated 29th November 2022.
Yes.
So this is an admission that it has been taken by the special officer of the bank.
Yes.
This, my contention, my lord, is this special officer was not vested with the jurisdiction, my lord, to pass this order of dismissal. There is no provision in law, my very respectful submission, which, my lord, authorizes the special officer here, my lord, to pass this order, take this decision. Because, my lord, I'll also indicate, kindly take up one document, which is through our RTI, page 341 of, my lord, volume 2.
So, against this order, you have preferred an appeal.
We
To
have,
the
which is
general
not
member.
considered, my lord. We have.
So what happened to that appeal?
They have, my lord, there's no outcome of the appeal because, my lord, according to them, this appeal is not, my lord, to be proceeded with.
Why?
We have filed, my lord, the appeal.
Why appeal not?
That is for them because we have indicated.
I do not find anything here.
Kindly take up the volume 2, it is there.
Volume 2.
Volume 2.
Yes. Volume 2, my lord, page 120, 130 is our appeal.
130.
Yes, that I've seen.
And my lord, page 131 onwards is the appeal in details where you have stated the facts, we have stated
Yes.
everything.
Yes.
Your lordship will kindly note thereafter this comes to an end, my lord, in 163. Because they did not, my lord, take any step, we have also indicated, my lord, thereafter.
What
Yes,
is this?
this is
dismissal
pending,
from 164?
That's the first writ petition, my lord. The first writ petition which has been disposed of with the direction, my lord, to immediately, my lord, dispose of within 7 days. That's at page
But I think
288.
it's better I direct them to dispose of the appeal.
Lord,
Yes.
now there is no relationship of an employer and an employee because, my lord, we have been dismissed. So unless, my lord, that
But that
dismissal,
the appeal will cannot be filed. What are you saying?
my lord,
Appeal
we have
appeal was filed.
So appeal cannot be
Appeal was
disposed
filed when
of,
was in
then
service.
What are you saying?
4 years back, my lord, we have filed the
That's a different-
appeal.
That's a different thing altogether. So dismissed employee
I'll
cannot
indicate-
have a right of appeal. What
My
are
lord,
you
the
saying?
order which has been passed by them, I have availed of, my lord, the remedy before the Article 226 court for this reason. My lord, the order which they have passed is unreasoned. It has to go. My lord, instead of the appeal relegating us back to the appeal, which will turn the clock back, my lord, it's been, my lord, 13 to 16. It's been 13 years, my lord. 26. We are in 26, my lord. This was originally show cause in 2013. 13, my lord. And I'll show, my lord, what they have, how they have conducted the proceeding.
You want expeditious, I can direct them to dispose of the appeal. That's one way you have taken all points, you can agitate.
You know, the difficulty is, my lord, once we have been dismissed,
Hearing
we,
matters,
my lord, we are apprehensive of an element of bias, and I'll indicate this very clearly, my lord, why.
one thing, yes.
My lord, I'll indicate this because the order, my lord, which we are assailing, I'll show from the records that it was passed, it reeks malafide of bias, my lord. And I'll indicate why. Your lordship will kindly take up page 288 once. volume 2 of the writ petition.
That you can, it's a hearing matter, it will
My
take
lord,
time.
it will take some time, my lord.
It will
And
take
I'll
time
argue.
first. Second is,
My lord.
I do not know what after the vacations, motions will be coming. Now the motions are not being, so it might be difficult. When this will be taken up, it's a very difficult thing. So that is
Kindly
why
don't
if you
relegate us
want
back to an appeal.
all-
We will argue this matter before your lordship, my lord, because we have challenged jurisdiction also. So kindly permit us, my lord, to any day, my lord, that suits the honorable court will come and argue. We'll bring
But
a,
it is difficult. So let it appear in the list. Then
my lord, the only difficulty is, my lord, perhaps then, my lord, will not be able to, my lord.
the date will be problem now, because after the vacations, I do not know how the motions will be. That is why
Any Friday in the second half, my lord, we'll conclude in one hearing, my lord. We'll bring the written notes of submissions and we'll, my lord, argue. We'll, my lord, chalk out all.
Friday usually the motions.
Any other day that suits.
I'm telling you, from 23rd or so April, none of the motions are done. So all the motions for more than a month, that's pending, and might be some are holding those because once the panel is prepared, they will be filed.
My lord.
These motions will come. So
Gotcha.
that's another difficulty, and this is the cooperative matter. Cooperative matter, the lawyers have requested only one off on Tuesdays. So motions thereafter. So that's the problem.
I understand that, my lord.
That's the
I
problem.
feel embarrassed, my lord, pressing this, my lord. That's
So
also something
that's another. And if you have any hearing bench exclusive, you can move there. Otherwise, with the motions, it might be difficult. And since you have an urgency also,
That's the only difficulty, my lord. Otherwise, I
so
wouldn't
that
have pressed.
is there's no other hearing bench.
Yes, there are. Irrespective of classification, there
Yes,
are benches.
there are benches. There are benches.
So I do not know. I have no difficulty in keeping it, but the only anxiety, your
May I-
anxiety is that
I understand what is. In fact, it is not embarrassing for me to make this submission. May I only pray for this? If it will not, if your lordship will not, may fix any day on in July instead of June. We'll come back in July, and we'll bring written notes of submissions. My lord, will in pointers. I'll conclude my submissions. I'll indicate what, my lord, how the proceeding has proceeded with, because, my lord, relegating us to appeal in my very respectful submission will, my lord, at this stage will not, my lord, because I am apprehending.
you have already preferred and
We did, my lord.
appeal.
We did.
You have already
They have not
preferred an
taken
appeal.
steps. 4 years, they have not taken steps. my lord.
Can we direct
That's a different thing.
Can we direct the general body members to dispose of appeal within a certain time?
You have not preferred any appeal.
We have.
Now, after you have preferred an appeal,
We have taken a point of jurisdiction now.
yes, now you have taken the point of jurisdiction.
Yes.
And you have taken the point of jurisdiction of the initiation of the disciplinary proceedings.
Indeed.
Second is, initially, prior to this, you have filed a writ petition.
That's only for disposal of, my lord, the main order was not passed till then.
Yes.
That, my lord, I'll
The order
indicate.
was not passed in what?
My lord, in the main proceeding. Kindly see, my lord,
Main
page
proceedings,
288.
the disciplinary proceedings.
Disciplinary proceeding
So
order
you
had
have
not been
not
passed.
challenged the jurisdiction then.
My lord,
So
we
whether
have-
it would not be barred by the principles of constructive res judicata, what you could
In
have
my-
prayed
in my
for,
res-
you have not prayed for at that point of time.
Madam,
You
can
did
you
not
see?
challenge the jurisdiction at that point
Madam,
of
can you
time.
see page
My lord, kindly
288?
my lord,
Can you
kindly
see page
So
288?
after you have allowed,
Kindly let me make my submissions.
after you have allowed the disciplinary proceedings,
You are making your
you
submission.
could have taken that at that point of time.
My lord.
So you have not taken that, approached this court for a direction, because it was open to you. Why you allowed that proceedings to be concluded?
My
You
lord,
could
we
have
have.
challenged then and there.
My lord,
So you have not challenged then and there.
lordship.
Then the disciplinary proceedings was concluded. You have preferred an appeal.
Well,
Now in the writ petition, you want to challenge that, giving a go by to the appellate remedy.
No, my lord, we have not given a go by, my lord. We have
That is-
participated there. The difficulty, my lord, today.
Participated, it has not been. So one way is to direct that. You can challenge that also, appellate order.
My lord, the difficulty, if we again go, that will be one round of proceeding more. My lord, the practical difficulty is this. It will be one round of proceeding more, my lord. Let me try, my lord, and address this honorable court on the merits of the matter and the jurisdictional point. If I succeed, I succeed. If I don't, my lord, then fate
You have
would
got
have it.
that point, whether after that writ petition you have waived your right to challenge.
Yes, I will argue that. The reason is, my lord, page 288. The first, my lord, writ petition, kindly see, my lord, the order at page 288. That will not be a constructive res judicata bar, my lord. It will not be a bar, my lord. Kindly take up, my lord, page 288.
Explanation 5.
My lord, that's constructive res judicata. It will
Yes,
not.
I'm on constructive res
It will not
judicata.
be a bar.
I'm
I'll
not on,
indicate that.
I'm not on
No,
res
no, I
judicata.
understand, my lord.
I'm on constructive res
My lord, it
judicata.
will
What points could have been taken, not taken?
not taken. My lord, it has been, but
So you could have raised that.
we have, my lord, and the honorable court has not gone into the merits and kept it open.
Res judicata, if you have not taken that point, court could not have gone into
But
that.
we have taken the point. Of jurisdiction in the first writ petition, we have
You
taken
have taken that point.
My lord.
Then if you have taken that point, you have not pressed that, ding waiver.
The honorable court, my lord, has indicated
taken
that
that point,
I
Mr.
am only directing not on the merits. My lord, that's why it will not be a bar, because the honorable court has not gone into the merits.
Judicata, Mr. Bag, is 11.
My lord.
Yes, what you have said, issue decided, conclusive.
And constructive, I could have, I have not taken. I understand that.
I'm on constructive,
I understand.
not on res judicata.
I follow
So, and if you have in the earlier,
Lordship.
so all the explanations will come. 5, relief claimed, which is not expressly granted by the decree deemed to have been refused. Explanation 4, any matter which might or ought to have been
taken,
made
but
a
has not
ground
been.
of defense. Here you have said, you have raised that point, but the court did not go into. The other thing is that you have not pressed. If you have not pressed, so it amounts to you have waived that point. At one stage, if you have waived that point at one stage, whether at the subsequent stage you can press that point.
But I have not waived. I'll indicate, my lord, page 288 onwards. If your lordship kindly takes up volume 2.
Yes.
Third paragraph onwards, my lord. By this writ
Page
petition,
288.
288, my lord.
Yes.
This is the order passed in the first writ petition.
Please take me to the first writ petition. Have you annexed that?
Yes.
Page.
Let's start from page 168, if I'm not wrong. 164 onwards.
Bias and everything you have taken that. Very
Lord, this
difficult,
is
Mr.
the
Bhatt.
reason, my lord, in the first writ petition, your lordship
All
will
the
kindly take the
grounds.
grounds.
Yes. Then
Your lordship will kindly see, my lord, this is without jurisdiction. We've taken that.
so all points you have taken there.
That is where, my lord, the honorable court has not gone into it and said, I'm not entering into the merits.
What happens?
This will not tantamount. I'll indicate that, my lord, because we have taken the. So it is not, my lord, that we have not taken the ground. If we have,
So you have taken that grounds.
my lord.
So it is deemed you have not pressed those grounds.
My lord, the court, honorable court was of the view that I'm not entering into the merits. This would not tantamount to me entering into the merits of the matter. I'm only, and I'll take your lordship to that order. But will kindly take up
page 288.
288.
Yes.
Page 288, my lord. Third paragraph onwards, my lord. Petitioner has challenged impugn order of suspension. So we had challenged the order of suspension, my lord. Passed more than 9 years back, 2013, 30th August, as appears from page 34 of the writ petition. Now at the fag end of his service career, petitioner has filed writ petition challenging disciplinary proceedings and suspension order. So we have challenged the proceeding as well as the order. Petitioner submits that the petitioner is going to retire on 30th November 2022. Had the petitioner been so serious in the matter, petitioner could not have waited for more than 9 years for filing the writ petition and suffered suspension order and going on enjoying 75% of the salary as subsistence allowance. Whatever may be the reason, the petitioner is still in service, and since the disciplinary proceeding has been initiated during the existence of the service of the petitioner, at this juncture and at this stage of this court could not quash the disciplinary proceeding, though there is an inordinate delay in completion of the said disciplinary proceeding, but to which there is a contribution of petitioner also. The writ petition is disposed of by directing, so it is only the direction given, Miller, directing the disciplinary authority to complete the disciplinary proceeding and pass a final order positively within 29th November 2022. So there was 7 days time given, Miller. By holding a day-to-day hearing, in case of failure to complete the disciplinary proceeding within the time frame, disciplinary proceeding shall stand quashed. It is with this in view, my lord, that they proceeded And they passed the inquiry report on 28th of November 2022, which is at page 104, volume 1.
Yes. I appreciate that the court did not enter into those merits.
On the merits.
But when
Well,
you have accepted this order,
we have.
so you have challenged the entire initiation of the disciplinary proceedings, pass everything. You have chosen to forego those points and only wanted an expeditious.
Lord, many a time, because this is, my lord, unless and until the honorable court goes into the merits. We have taken the point.
That's res judicata under section.
Indeed, indeed. Where we are on constructive res judicata, my lord. We've taken the point which we ought to. So, my lord, constructive res judicata, the first stage, but my lord, whether the
not press.
I'm very grateful, my lord. We have not pressed the issue. And, my lord, if the honorable court's order
not raised unless
my lord,
you have appears that you have pressed that, it will be deemed that you have not pressed.
but there is perhaps, my lord, there are line of judgments which say this, my lord, I am aware. But, my lord, there's one line of judgments my lord, I'll try and, my lord, place them before the honorable court.
That's the thing.
On the point, my lord.
Usually what happens is when you come, you suffer an order for a subordinate forum.
We press for that one line recording, my lord, that kindly record, my lord, that the other points have
Not
not been
on
gone
that,
into and should not
then
be
you
recorded.
come up. Then
Lordship.
you come up in appeal or revision, whatever
lord.
it might be. And you say, look, when the court poses a question, yes, did you raise this point? Did you raise that point? You said, yes, yes. Look, in the petition, I have taken this. Have you raised that point? Yes, I have raised that point. Court did not record that.
My lord.
So, why this is necessary? So, if you have pressed and not recorded, then you have to go back to that court, say, yes, why that is necessary? Because you may have taken 10 points.
Lordship.
Now, in course of hearing, you find, no, I should not press these 7 points. I will press only these 2 points. These are my good points. If I succeed, I succeed. I will not press those. So you choose amongst out of those 10, only 2. Now, on that 2, you could not succeed. Then can you say, in the higher forum, you say, no. Look, there are other points also. This also ought to have taken. You cannot. Because those were raised, you have not pressed or not pressing. There are meant 2 things. You can say, yes, I'm not pressing that. At times, we are also recording, asking you. But it may be that there are points you did not press, you have pressed 10. Also amounts to shall be deemed that you have not pressed that. You have waived your right.
There are line of I'm aware of this, but if the order is silent on a particular prayer, it means there's a deemed refusal of that prayer.
That's explanation
Indeed.
So that's one thing. Also, there are line of distance, even without going to those constructive res judicata issues not pressed. So, deemed waiver.
May I only try and canvass my submissions on this issue on the next day when the matter is taken up? I'll bring judgments, my lord. I'll place my submissions. I'll try and convince your lordship
because at this
that
late
if, my lord,
stage,
if this point was not, my lord, could not have been raised by us, because my lord, this judgment we are referring, my lord, replacing reliance on the coordinate bench decision is a 2025 decision, where it has been held in the same person's case, my lord, and it is for them to indicate whether they have preferred an appeal against this. Otherwise, it will bind them, my learned friends. Because, my lord, paragraph 23, they were called upon to indicate which is that regulation by which this vesting could be done. They have not shown it. Same regulation, same party, and it's the same CEO.
There might be no other regulation. The question is,
my lord,
by virtue of section 36, can manage the affairs of the society.
But that has been explained.
What does it mean to manage the affairs of the society? So, what he will be doing, special officer? How he will manage? What will
day-to-day, my lord, functioning of the cooperative society
means what he will do? All officers are there, all staff, they will run the business. What the special officer will do?
My lord, sanction, my lord, give sanction. My lord,
what sanction?
To the financials, my lord, to the other
cannot do that.
Which are, my lord,
major policy decisions he cannot take.
Day-to-day affairs, whatever is the day-to-day. Yes. That's my submission. But a termination of an employee cannot be equated, perhaps, my lord, with a day-to-day functioning of, my lord, the proceeding, especially when, my lord, the initiation of the proceeding happened in 2013. And the first line there, my lord, states that the board of directors is not in session from 2020 October. So from 2020 October means, my lord, 7 years.
When the proceeding was initiated, special officer was not there.
Was not there. And
So-
that is why, my lord, the special officer has indicated that I have passed this order by, my lord, assuming jurisdiction. My contention is he could not have assumed jurisdiction. If the, my lord, if he has to pass that, my lord, that threshold of
This
jurisdiction,
disciplinary proceedings will continue for years together. If there is no constituted board, it will be to your detriment.
it should have been, my lord, much
Would be to
prior,
your
much
detriment
prior
then.
to 2020. That's my case.
That's not done.
That's not
So,
done.
so if that is not done,
That's
then
not done.
all right, it is set aside. Then the regular board, so it will be to your detriment. It will further delay.
It would be, Lord, because otherwise, you know, the board of
Yes.
directors has to come in. If the board of directors is not there, but there's also a
So it will
provision
be
which
to your
states
detriment. It will further delay.
the board of directors also has to come, my lord, within a particular time frame. So that
It's
is
not
also
done.
not done.
That
2
does
years
not
it
be,
was not done.
then
2022, this order is passed.
this will add to the delay and you will suffer only for that. It will be to your detriment.
But I've
If you
understood
take
what is
that
calling
plea.
from your lordship, my lord. I will try and canvass my submissions with regard to these points. I'll try and
Because
address
these
the
things,
honorable.
if these points are taken, that goes against the employee. Any employee, I'm not telling
Lord,
about.
indeed, indeed.
So it will add to the delay, process will be delayed, because these are the usual features. Board of, the term or tenure of the board gets expired, then special officer, 1 or 2 times they are appointed, then elections cannot be, several litigations. Then at one point of time, nominated board comes, he goes on, then the highest paid employee, he comes. So none of them can take a decision. So it will be to the detriment of the person who has been suspended. Suspension will continue. Difficult.
I'll try, my lord. I'll try and come back.
If
I understand what is falling from your
has to
lordship.
be
Three
given a
broad
wider
points.
meaning. This managing the affairs, if it is given such a narrow meaning,
I'll
it
see
will
if there are any
be at
other
the cost
authorities
of
on
the
the
employees.
phrase, interpretation of the phrase, my lord. I'll
Because
try.
the authorities have nothing to lose. They will keep it pending.
That they have done that, my lord.
Yes.
For 13 years they have done that.
So it's against the interest of the employee. So now if you say no, they cannot do that. It has to be set aside and it is to be by the board of directors. Then.
This is, my lord, the point of jurisdiction. Lord, I have other points on merits which I could not have taken before because
If
the order is now.
jurisdiction is in your favor, then everything goes. Then it has to start from the beginning.
No, my lord. If the jurisdiction is also decided in their favor, I'll show.
No, if that is decided in their favor, then you have other points.
Then I have.
But
Lord,
if it
then,
is in
then I
your
will-
favor,
my lord.
it will further delay.
But may I indicate this? If the jurisdiction is in their favor, my lord, then on the merits, there can't be a constructive res judicata, my lord, because at that point in time, this order was not there. Then I'll show, my lord, this order itself is bad in law and how it is unreasonable without reasons. It has to go and it is based on bias, and I'll indicate that from the record.
What is this application for?
That's for expeditious disposal, my lord. Because that will be
Can I direct them, my lord? My lord, I do not have any document. Can I direct them to file to give me the evidence in opposition and the reply?
Definitely.
Opposition, please give.
Yeah, on the reply. The reply to the filing today.
Baglan
একটু কাইন্ডলি ফাইলটা দেবেন একটু।
Otherwise, Lord, he has to have a leave from the Honorable Court for filing the affidavit in opposition. That is the reason.
Please check up that, then you have to reaffirm and file afresh.